The House will come to order. The Pledge of Allegiance will be led by Paisley, Gracie, and Titus Tom Payne from Flatirons Elementary School, Boulder Valley School District, guests of Representative Smith.
Will you join us for the Pledge of Allegiance? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Very well done. Mr. Shebel, please call the roll.
Representatives Bacon, AML Bacon is excused. Barone, Basenecker, Speaker Pro Tem Basenecker,
Excused.
Bottoms, Bradfield, Bradley, Representative Bradley,
Excused.
Brooks, Representative Brooks,
Excused.
Brown, Caldwell, Minority Leader Caldwell,
Excused.
Camacho, Carter, Clifford, DeGraff, Duran, Majority Leader Duran,
Excused.
English, Representative English,
Excused.
Espinoza, Representative Espinoza,
Excused.
Foray, Representative Foray,
Excused.
Flannel, Froelich, Rep. Froelich,
Excused.
Garcia, Garcia Sander, Gilchrist, Goldstein, Gonzalez, Hamrick, Hartsook, Jackson, Johnson, Representative Johnson is excused. Joseph, Kelty, Representative Kelty is excused. Leader, Lindsay, Luck, Lukens, Mabry, Marshall, Representative Marshall is excused. Martinez, Morrow, McCormick, Wynn, Representative Wynn is excused. Pascal, Phillips, Richardson, Ricks, Representative Ricks is excused. Rutinel, Ryden, Sirota, Rep. Sirota is excused. Slaw, Smith, Soper, Stewart K, Stewart R, Story, Sukla, Taggart, Titone, Representative Titone is excused. Valdez A, Velasco, I saw her earlier. Representative Velasco is excused. Weinberg, Wilford, Rep. Wilford is excused. Winter. Woodrow. Woog. Zokai is here. And Madam Speaker.
With 52 present, 13 excused, we do have a quorum. Madam Majority Leader.
Thank you, Madam Speaker. I move that the Journal of Tuesday, March 24th, 2026 be approved as corrected by the Chief Clerk.
Members, you have heard the motion that the journal be approved as corrected by the Chief Clerk. All those in favor say aye. All those opposed, no. The ayes have it. The motion is adopted. Members, we are going to go to announcements and introductions before third reading. I hope everyone has signed up. Representative Phillips, thank you for your diligence.
Thank you, Madam Chair. Today, I would like to recognize the Adams 12 District Wrestling Team at the Capitol. These are the placers and regional champions taking a break from sprawling to get civically involved. The team represents Thornton, Horizon, North Glen, Legacy, Mountain Range, Stargate, and Prospect Ridge High Schools, and I am honored to recognize the placers from the 5A state tournament and regional champions, Cada Hull, Acadia Puga, Brooklyn Gustafson, and Betty Rains. And I'm also excited to recognize Emily Moen and Betty Rains, who have committed to Western College University and William Penn University to continue their wrestling careers. For the past 6 years, the team has worked hard to reach the top and is now recognized as one of the premier girls wrestling programs in the state. The program is led by Colorado native All-American and educator Kaylee D. Herrera. Congratulations to the team. Keep representing Adams 12 the right way. Hard work, discipline, pride in everything you do. Please welcome them. Stand up.
Congratulations. Representative Hartsook.
Good morning. Thank you, Madam Speaker. Common Sense Institute was here this morning at 8. They're serving breakfast out there. If you have the chance, swing by and say hi. They do a lot of work that you use for research and legislation. Thank you so much.
Representative Lukens.
Thank you, Madam Speaker. The House Education Committee will be meeting 10 minutes upon adjournment in room 107. We will be hearing House Bill 1317.
Representative Stewart.
Thank you, Madam Speaker. The Transportation, Housing, and Local Government Committee will be meeting at 1:30 to hear Senate Bill 26, House Bill 1300, House Bill 1330, House Bill 1313, and House Bill 1061 for action only in LSBA.
Thank you. Representative McCormick.
Thank you, Madam Speaker. I want you all to recognize and welcome the Northwest Chamber of Commerce that are all here in the gallery. They represent 7 chambers of commerce from Boulder to Broomfield to Louisville, Longmont, Lafayette, Superior, and the Boulder County Latino Chamber. They are here till noon. They will be down in House Committee Room 109. So please welcome them and then go say hi when you can later today.
Representative Gilchrist.
Thank you, Madam Speaker. The Health and Human Services Committee will meet today at 1:30 to hear the sunset review of the Colorado Podiatry Board, Senate Bill 031, Senate Bill 077, and House Bill 1249 for action only. We'll see you there.
Thank you. Representative Tatone.
Thank you, Madam Speaker. Members of the Joint Technology Committee, join us tomorrow morning at 8:45. We're going to have a discussion on bill drafting for a proposed bill in room 352. Be there at 8:45.
And Representative Camacho.
Thank you, Madam Speaker. Colleagues, the Business Affairs and Labor Committee will meet 15 minutes upon adjournment, and we'll be hearing Senate Bill 76 and House Bill 1247 in that order.
Thank you. Judiciary, Representative Mabry.
Thank you, Madam Speaker. Judiciary Committee members, we are meeting today at 1:30 in the Old State Library, and we're going to hear House Bill 1322 and Senate Bill 18. Old State Library today, 1:30.
And Speaker Pro Tem Basenecker.
Thank you, Madam Speaker. Just a quick announcement, colleagues, that tomorrow morning, counties and commissioners acting together, CCAT is holding their legislative breakfast, 7:30 to 9 outside the old Supreme Court chamber. They represent county commissioners across Colorado. Great chance to connect with those folks who are doing hard work on behalf of all of our communities. And I hear the burritos are going to be delicious as well. So multiple reasons to stop by and say hello to your county commissioners. Tomorrow morning, 7:30.
Thank you. Representative Valdez.
Good morning, Madam Speaker. The rare but amazing Energy and Environment Committee for the House will be meeting today upon adjournment to hear House Bill 1225. Come one, come all. And I think it'll be about 15 minutes after adjournment, but I will make sure everybody knows.
Great, thank you. Members, I understand that Audit Committee is still meeting. We will take a short recess. Please do not wander far from the chamber. The House will stand in recess. Members, audit has adjourned. We're giving them 1 minute to return to the chamber, but we'll be gaveling in 1 minute, and we do have third reading. The House will come back to order. Members, we are moving to third readings. Please take your seats. Madam Majority Leader.
Madam Speaker, I move to lay over Senate Bill 43 until tomorrow.
Seeing no objections, Senate Bill 43 will be laid over until tomorrow. Mr. Shebel, members, we are on third reading. There should be no conversation. Please take your seats. Mr. Shebel, please read the title to House Bill 1339.
House Bill 1339 by Representatives Duran and Garcia, also Senator Danielson, concerning a change in the name of the voluntary legal holiday observed on March 31st from Cesar Chavez Day to Farm Workers Day.
Madam Majority Leader.
Madam Speaker, I move House Bill 1339 on third reading and final passage.
Representative Luck.
Thank you, Madam Speaker. This resolution, it feels like a resolution because it's not in capital letters, so forgive me. This bill came to my committee earlier this week. And during the committee, I asked two questions. Two questions I reiterated yesterday on second reading. The first question was, did the bill sponsors consider changing the date? Because the date that was selected was the man in question's birthday. And if the desire is to distance from the man in question, did they consider also distancing from that aspect of the story? And in having conversations on the mic and off the mic, I've come to better appreciate the conversations around this bill in various communities and understand that there are many conversations yet to come. So I appreciate that. The second question that I asked was, what evidence exists to substantiate the allegations? The allegations that are being used to remove an honor that was given to this man. The man is dead. The allegations are from many years ago. And so how do we know? How do we know that we are standing with the just side of this equation? What substantiates these claims? And I was pointed to in committee a variety of supporting evidence, minutes from farm worker meetings, and other corroborating evidence that supports these allegations. Because this individual had passed away, he can have no day in court. He cannot defend himself any longer. And so we, in this part of history, have to make our best judgment on what happened years ago. And so I stand here in support because I believe that what was shared does substantiate the claims here. I note that there is nearly every name already listed as co-sponsor on this resolution, supporting an action to defend women we've never met, or likely never met, some may have, but most have never met, against a man we'll never know. I ask that this body, in the days and weeks to come, when they are asked to make a determination about people we do know, that you hold the same standard.
Representative Gonzalez.
Hi, thank you, Madam Speaker. I just again want to come up here and commend the sponsors for how fast they were able to get this done, given the recent allegations that did come out. And I think this is a reminder that we should move fast to protect not only survivors and victims, that, especially of sexual assault and violence, but our women and our children and people of that nature who, sometimes we break barriers and there's just too many taboos and people are afraid to come forward. And, there comes a time when people reflect and, the culture that was then is not the culture we live in now. And I think we should hold ourselves to that and remind ourselves that the environment we are in today, after the Me Too movement, has kind of fostered this environment where now people are more open and comfortable to come forward versus decades ago. And I think this is something that, the same arguments could be said about anyone else that has passed. And, what happened to believe all women? What happened to believe victims and hear them out? Because at the end of the day, I don't think people would just fabricate stuff like this, especially at this point in time. And what we see nationwide across the country with, polarization, we should take these allegations very seriously. And so I encourage an aye vote, and I commend the sponsors for the work on this bill. Thank you.
Representative Garcia.
Thank you, Madam Speaker. Today, like we said yesterday, this is a day that's full of sadness and horror and anger, and it's also a day that we can be joyful and proud and celebrate. We have a chance today to not only honor victims and survivors and say, yes, we believe you, we also have a chance to return this movement to its original roots of being for and by farm workers. That is why this is so important today, and I am grateful to every single one of you that said, yes, that is what we need to do today. And for all of you, and those of you who may not have signed on as a co-sponsor but will still vote yes, you are helping to make history, to set precedent, and to make sure that the entire communities out there, farm workers, the Latino community, agriculture, that they know how important we believe that they are. And for the victims and survivors in this world, whether it's in movement spaces or it's behind the car of a gig driver, that we stand with victims and survivors. Thank you all, and I hope to see every single name on this board light up green today. Thank you.
Seeing no further discussion, the motion before us is the adoption of House Bill 1339 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Please close the machine. With 64 ayes, 0 no, and 1 excused, House Bill 1339 is adopted. Co-sponsors. Please close the machine. Mr. Schiebel, please read the title to House Bill 1214.
House Bill 1214 by Representatives English and Jackson, also Senator Amabile, concerning the continuation of the Colorado Licensing of Controlled Substances Act and in connection therewith, implementing the recommendations contained in the 2025 Sunset Report by the Department of Regulatory Agencies.
Madam Majority Leader.
Madam Speaker, I move House Bill 1214 on third reading and final passage.
The motion before us is the adoption of House Bill 1214 on third reading and final passage. Mr. Schiebel, please open the machine and members proceed to vote. Rep. Mabry. Rep. Mabry, that's a $5 fine. Please close the machine. With 43 aye, 21 no, and 1 excused, House Bill 1214 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1242.
House Bill 1242 by Representatives Pascal and Jackson, also Senator Roberts, concerning interlock restricted license requirements for impaired drivers and in connection therewith making an appropriation.
Madam Majority Leader.
Madam Speaker, I move House Bill 1242 on third reading and final passage.
The motion before us is the adoption of House Bill 1242 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. English, Garcia. Rep. Garcia, $5 fine. Please close the machine. With 56 aye, 8 no, and 1 excused, House Bill 1242 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1260.
House Bill 1260 by Representatives Garcia and Wilford, also Senators Cutter and Bright, concerning programs for child care assistance.
Madam Majority Leader.
Madam Speaker, I move House Bill 1260 on third reading and final passage.
The motion before us is the adoption of House Bill 1260 on third reading, final passage. Mr. Shebel, please open the machine and members proceed to vote. Please close the machine. With 63 aye, 1 no, 1 excused, House Bill 1260 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1188.
House Bill 1188 by Representatives Camacho and Titone, also Senator Kolker, concerning the continuation of the regulation of securities and in connection therewith implementing the recommendations of the Department of Regulatory Agencies in the Department's 2025 Sunset Report.
Madam Majority Leader.
Madam Speaker, I move House Bill 1188 on third reading and final passage.
The motion before us is the adoption of House Bill 1188 on third reading and final passage. Mr. Shebel, please open the machine and members proceed to vote. Please close the machine. With 43 aye, 21 no, and 1 excused, House Bill 1188 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1006.
House Bill 1006 by Representatives Velasco and Martinez, also Senator Roberts, concerning the designation of state institutions of higher education as thriving institutions.
Madam Majority Leader.
Madam Speaker, I move House Bill 1006 on third reading and final passage.
The motion before us is the adoption of House Bill 1006 on third reading, final passage. Mr. Shebel, please open the machine, and members proceed to vote. Please close the machine. With 43 aye, 22 no, and 0 excused, House Bill 1006 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1197.
House Bill 1197 by Representative Morrow, also Senator Kipp, concerning the continuation of the vessel registration program.
Madam Majority Leader.
Madam Speaker, I move House Bill 1197 on third reading and final passage.
The motion before us is the adoption of House Bill 1197 on third reading, final passage. Mr. Shebel, please open the machine, and members proceed to vote. Please close the machine. With 55 aye, 10 no, 0 excused, House Bill 1197 is adopted. Co-sponsors. Please close the machine. Mr. Shebel, please read the title to House Bill 1269.
House Bill 1269 by Representatives Ricks and Joseph, also Senator Marchman, concerning transit access.
Madam Majority Leader.
Madam Speaker, I move House Bill 1269 on third reading and final passage.
The motion before us is the adoption of House Bill 1269 on third reading, final passage. Mr. Shebel, please open the machine, and members proceed to vote. Please close the machine. With 43 aye, 22 no, and 0 excused, House Bill 1269 is adopted. Co-sponsors. Please close the machine. Representatives Brown, Sirota, and Taggart are excused at such time as necessary for the Joint Budget Committee meeting. Madam Majority Leader.
Thank you, Madam Speaker. I move the following bills be made special orders on March 25th, 2026 at 9:49 a.m. House Bill 1320, Senate Bill 118, House Bill 1195, Senate Bill 88, and House Bill 1304.
Seeing no objection, the bills listed by the Majority Leader will be made special orders today, March 25th at 9:49 a.m. Representative English. Members, you have heard the motion. Seeing no objection, Representative English will take the chair.
The committee will come to order. With your unanimous consent, the bills will be read by title unless there is a request for reading a bill at length. Committee reports are printed and in your bill folders. Floor amendments will be shown on the screen on iLegislate and in today's folder on your box account. Bills will be laid over upon motion of the majority leader. The code rule is relaxed. Mr. Sheba, please read the title of House Bill 1320.
House Bill 1320 by Representatives Nguyen and Garcia concerning statutory requirements for ballot title language and in connection therewith, requiring the use of accessible language and allowing for the modification of statutorily required ballot title language.
Representative Nguyen.
Thank you, Madam Chair. It is an honor to serve with you.
It's an honor to serve with you.
I would like to move the committee report to the committee of the whole.
To the committee report. 1 second, you got to move the bill first. Sorry.
You move the bill and the committee report.
I would like to move the bill and the.
Say 1312.
I would like to move House Bill 261320 and the committee report.
To the committee report. Representative Garcia.
Thank you, Madam Chair. Members, in Committee of State Affairs, we brought an amendment that clarifies what we mean when we talk about accessible language, and we asked for an aye vote.
Is there, Representative Lutt, you want to speak to the committee report? Okay. Is there any further discussion on a committee report? Seeing none, the question before us is the adoption of the committee report. 1 second, brief recess.
Your amendments to the committee.
The committee will come back to order. We have an amendment to the committee report, so we're still on a committee report. Representative Luck.
Thank you, Madam Chair. Yes, we do actually have an amendment to the committee report. My apologies this morning. So I move L004 and ask that it be displayed.
L004 has been displayed. Representative Luck to the amendment.
Thank you, Madam Chair. It's unfortunate that this is to the committee report because I think it's important that the bill sponsors be able to frame their own bill, but that is the process in which we are in. And so I'm going to need to lay some foundation in order for this amendment to make sense. This is one of a few bills that
1 second, Representative Luck. Members, can we keep our conversations down? Thank you. Representative Luck.
Thank you, Madam Chair. This is one of a few bills that are coming through this year related to ballot initiatives and language that is used on those initiatives. It's important to understand that these particular requirements apply to citizen initiatives. Because under citizen initiatives, you have the title board who makes a decision. The other way you can get questions on the ballot is through a referred measure. Referred measures, as you all know, are measures that this body approves. And because this body approves, a legislator could conceivably have a particular issue that he or she wants to drive out into the state through a referred initiative, a referred measure, and go through, this particular legislator could go through the process of polling language, seeing which words and which orders will result in greater success, and then have that added to their resolution in this space. And unless somebody in this building has enough votes to override that particular framing, that is the framing that ends up on the ballot. Which means that the legislature has more ability to ensure its referred measures pass than citizens do with their initiatives. And that's unfair. Citizens come with their ideas and their tens of thousands of signatures, and they ask the title board, please have mercy on us in the way that you frame this. And there are citizens who come prepared and they say, here is our draft language. This is what we would most like to see as the question. Because they too could go and have those same pollsters, do those same studies to figure out that same winning language and apply it. But under law, the title board doesn't have any impact, or can impact very greatly, doesn't need to take into account really what they have submitted. They could completely ignore it and set their own title. And there is a question there of fairness. A question that is actually exacerbated by one of the elements of the introduced bill that is before us. You see, in this particular bill, there are many a section that shifts the current rules related to how a ballot title reads and is ordered. I don't know about you, but I have some constituents who, when they want to sit down and talk about their ballot with me before they vote, and they're reading through questions, and the question says, shall there be a reduction to blank tax? They're like, no, I don't need your help on this one. Yes. Circle that little dot. They don't get any further. And there similarly is a response when it says, shall there be an increase in X tax? And you know what they do? That's right. Good job. They circle in really quickly that no circle. They don't read any further. They don't. And under this bill, this body is giving the title board the authority and ability to rewrite that portion of the question and to reorder it, which, as we all know, will likely impact outcomes. Because if the question starts not, shall there be an increase in X tax, but instead, shall the state save puppies? And then it's 42 paragraphs long after that, they're like, yeah, I think the state should indeed save those puppies. Yep, circle that in. And it stands to reason that because the title board receives a number of different requests every year, that some of the requests will start out, shall there be an increase in tax or reduction in tax? Whereas others will start out, shall we save puppies? How do you address that particular unfairness, wanting to honor the underlying purpose of this bill, which is to promote clarity, to promote readability, to promote understanding? Using a common term in this building, how do you thread the needle between wanting to give the title board the discretion to make a sentence flow in a way that makes sense, that is common language, that leads people to a conclusion of a yes is a yes and a no is a no because we've avoided double negatives. All of those things are valid and good. But how do we protect against any sort of bias that could be used to influence unjustly and unrightly the outcome at the ballot box? And so this amendment seeks to try and thread that needle and I'll read it because I feel like either my eyes are getting worse or the screen is getting smaller, so it's harder to see from the back of the room. And while there are a few people here, I'd still just read it for those who can't see the board. It says, to add in to the amendment proposed in committee in both sections that were proposed in committee, that the proponents of a proposed initiative may submit a draft title to the title board in advance of the title setting meeting. The draft title submitted by the proponents of the proposed initiative is presumed sufficient, and the title board shall only modify the language used in the draft title to meet the title board's constitutional and statutory duties. In other words, I believe that a good way to try and thread that needle is to say, citizens, in the same way that we empower legislators to set their own title, we will also allow you the opportunity to set your own title. And if you do it properly, if you've looked into the law and you see you have to have this language and not that language, and it has to do, have so many commas and capitalizations, et cetera, and you do it all, we're going to say that's good to go. If you meet those check marks, then you got to set it. Because I think the last thing that people in this room should want is for the citizens who go through this long process, arduous process, costly process, especially those who aren't paying consultants and petition gatherers, but are the ones who are out at every event they can possibly be at, all hours of the day and night to get those signatures, that the power should be within their ability. They should have the ability to set themselves up for the greatest level of success, in the same way that this body does. It's not fair that maybe if they don't, they can see the disparity and how different questions are treated. I believe that our nonpartisan staff seek to be nonpartisan. But the reality is all of us have a bias. And whether we believe it or not, that bias can come out in the most subconscious of ways. And so I ask that we support this so that the bias that is included in our blue books is the bias of the people who are proposing the idea. There are a lot of hurdles to getting a ballot initiative passed, especially for those who are not linked to lots of money. And this is just one way to ensure that that beautiful process that Colorado has instituted for the citizens to engage their government in this way remains as fair and true as possible. I ask for an aye vote.
Representative Bradley.
Thank you, Madam Chair. It is an honor to serve with you, my friend.
It is an honor to serve with you too, friend.
Thank you. I believe we discussed this amendment in the committee, and we talked to the sponsors about addressing the fact that legislator-driven initiatives don't have to jump through all these hoops, but citizen initiatives do. And where is the fairness in that? And so I thought that we had talked to the bill sponsors about accepting an amendment that would make sure that citizen-initiated ballot measures don't have to jump through the same hoops that the legislator-driven ones do. In the spirit of fairness, someone said, "He who frames the issue wins the argument," and that is truth. So if we allow the title board to do these things, what we should be doing and legislating in here, I keep seeing bills this year that are rules for thee but not for me, including this building here. A diaper changing bill, another bill that carved out all state buildings so we can drop fiscal notes. That is not the rules for everyone. This amendment was drafted carefully and cautiously to make sure that citizen-driven initiatives can be plainly written and neutral and not biased. If legislators get the say in the initiatives, why can't citizens also get the say in how their initiatives are drafted? And this bill is a good bill. It's got a couple of things I think if we could amend, then we could have bipartisan support. I don't know why there's only Democrats on this bill. I feel like this could be good bipartisanship. I think the Blue Book and a lot of these initiatives are very, very confusing. They're run-on sentences, they're long. One of the sponsors came and read through how eliminating double negatives and things like that can make it clearer, avoid the run-on sentences, and help people truly get involved in the ballot process and be able to vote. And she made some great, she brought up Initiative 95, very difficult to understand. Then she rewrote it through a reading program, and it came out at a high school level versus like a doctorate level. And so I agree with that. I agree that the Blue Book should help. I honestly, I love when people call me, but I get tired of them calling me about ballot initiatives. It is over and over, and half the time I can't even understand them. So we need to make this clearer for the people of Colorado. But if you're going to do it for the citizen-led initiatives, by golly, you need to do it for the legislator initiatives as well. Because if you think those are clear, I've talked to some of you, you're not that clear. I'm Southern, I'm not that clear. Lawyers, you're not that clear. So why don't we make it fair and just and right and transparent and accountable for both sets of ballot measures? If we're gonna do it, let's knock it out of the park. Let's do it for the legislator ones, and let's do it for the citizen-led ones. In the spirit of bipartisanship, which I'm struggling on, boy, I'm struggling halfway through session to see the bipartisanship in here. Struggle bus. This is a good amendment. It's a fair amendment. It's a clear amendment. I mean, the rep from Penrose just read it to you guys, all of you that are listening, all 5 that are listening. Thank you, rep from Jeffco. Appreciate you listening. You always are. It's a fair amendment. Let's make it clear for the people of Colorado. Cut down the phone calls to me during the summer. It'd be awesome. And let's vote yes for this amendment in the spirit of what the sponsor said in committee of making citizen initiatives be just as fair as the legislator-driven ones. Thank you.
Representative Bottoms.
Thank you, Chair. And I want to say I enjoy serving with you.
It's an honor to serve with you, too.
This amendment, I think, is pretty good. So I did listen to this in committee. I didn't really disagree with anything that the sponsors said or any of the testimony that coming forward. I will talk about a couple little concerns I have about the bill when we get to the bill, but I do find these titles, in fact, my wife and I have discussed it for many years now. It seems like there is a person that their only goal is to make these confusing, that the titles are truly confusing. There's no doubt about that, and sometimes deceptive. But I do think that there needs to be some equality here when it comes to all titles of bills, how this works from the state or from the constituents. And so I do think this is a good amendment. I definitely can get behind this bill with just a few little changes and vote yes. And I think it really would become a very bipartisan bill if we can just tweak a little bit of this. I don't like the idea, and I don't think this was the intent of the sponsors, but I don't like the idea of why do we force things on the people, but we don't hold the state or this body accountable. And so I do think this is a good amendment. I do think that we should vote yes on this amendment.
Representative DeGraff.
Thank you, Madam Chair. It's just an honor to serve with you. Okay. I said it, I'm sorry. It's an honor to serve with you.
It's an honor to serve with you, too.
Okay, I'm in favor of this amendment. That's why I'm up here. And I think we ought to incorporate it. I think this is what seconds are for. This is how we refine the bill. This is how we talk about. This is where we take the bill and we try to work out the details. And this is a detail that we need to work out. And knowing some people on the wording of this is very important. For instance, and the wording is very important, as we talked about, because whoever frames the argument is going to have an advantage. And for anybody who's listening, when you get the Blue Book, which is only because of the Taxpayer Bill of Rights, that says without raising your taxes, what they're doing is they're raising your taxes. So I'm just going to decode that for you right now. It's in the Blue Book because they're raising your taxes. Or they're replacing a tax with a new tax where otherwise your tax would go down. So anyways, let's talk about this. When we get into subjective language and we're approving what I would say is a highly partisan organization to start making their own determinations as to what something says, then we have a problem. Then we are going to have this ideological organization no longer tied to this. And previous legislation this year has already made ballot initiatives more difficult for the sake of making it more difficult, because I'm pretty convinced at this point that this body does not really care what the people of Colorado think. And we're going to rush towards increasing regulation and restrictions and taxes at all turns. And so one of the examples I'd say is in terms of subjective language is the term, and you might find this out, but a petition was recently rejected because the term parent was too broad. And if the term parent is too broad, then I think that we have a problem as a parent. Because there are legal definitions for parent. And when you have an organization that we would basically be turning over the language to on these bills, on these ballot initiatives, that cannot look up the legal definition for the word parent in order to honor the work, the effort, the money, the time, then I don't think that organization should be trusted with really anything. And that's by their own demonstration. Because just for example, the terms parent and guardian carry significant legal weight in family law, child welfare, education, health care across the United States. Statutes define who qualifies as a parent or guardian and outline the accompanying rights and duties. These definitions impact custody decisions, consent to medical treatment, ability to make educational choices, and responsibilities for financial support. Although many principles overlap, state laws shape the specifics, including how parental status is established, who may assume guardianship, how rights can be terminated or transferred. This article explains the core concepts of how they apply in common situation. What counts as a parent under U.S. law? A parent is generally someone who has legally recognized relationship with a child and bears parental rights and obligations. Core categories include biological parents, adoptive parents, presuming parents. In most cases, a biological parent has a natural rights and duties unless those rights are limited or terminated by the court. Adoptive parents require full parent rights upon finalization of the adoption, with responsibilities including support, care, and decision-making authority for the child. And in many contexts, a person married to the child's other parent who is legally recognized parentage through the court may also be treated as a parent for certain purposes, step-parent. So we have an issue currently that we're not resolving with our title board. We've already made petitioning the government, we've already made the First Amendment rights of the citizens of Colorado more difficult. And so now we're going to do it again, and now we want to give what I would say is by this event. I think if you can't look up if an organization that's entitled with these titles is either ideologically captured or just idiotic, because there are definitions. And so we need to go back and look, why would we be giving this organization that can't look up the definition of parent any more authority? Why would we do that? Because the only thing that this, and I agree with my colleague, that this could be a good bill. There's always language that we might need tightening up. But turning this over and increasing the authority of what I'd say is clearly an ideological organization or ideological captured members, that we have a problem, because they're no longer representing the rights. They're no longer in this position to secure the certain self-evident creator endowed rights, among which are life, liberty, and the pursuit of happiness, and then the derivative rights of the First Amendment to petition their government. If we are going to take their speech, and then this organization is going to manipulate that speech into what they find is ideologically aligned with their capture, then we are no longer representing the citizens of Colorado, and instead of this body acting in alignment with securing the rights of the citizens of Colorado, it is actually standing in contradiction to it. So it doesn't really matter. So the example here is that we have an organization that has some problems. What we've done in this room is not make those problems better. We've made the burden on the citizens of Colorado worse. And the purpose, the only purpose that we have in this room is to secure those rights. Declaration of Independence, let's just go all the way back to the beginning. Our job in this room is not to make the trains run on time. The job is to secure
Representative
the
DeGraff,
rights.
are we to the amendment?
Absolutely.
Okay.
Haven't left. So, what I'm asking for is this, just to work with us on these amendments. What we're trying to do is we're trying to make the bill better. We're trying to preserve and we're trying to secure the rights of the citizens of Colorado, not to make, and then from there, after we've secured the rights of the citizens of Colorado, to petition their government, that they have the right to petition their government, that when we've secured that right, then we can work on the finer points. But right now, we've not worked on securing the rights of the citizens of Colorado, and we're actually undermining them. So I recommend a yes vote on this amendment. This is a carefully thought through amendment. And it is for the purpose of securing the rights. It's to make the bill better. That's all. I recommend an aye vote.
There any further? Representative Bradley.
Thank you, Madam Chair. I just wanted to make sure everyone is listening, that the title board thought parents was too broad of a term. The title board thinks that the title board in Colorado thinks that the term parent is too broad. That's why you're pulling kids out of schools. That's why you're not going to certain doctors. That's why our educational system is in crisis, because 20,000 kids have left public schools. Colorado's title board has ruled that the term parent can be too broad or unclear. Not for my taxes, not when I file my taxes. I'm the parent of 4 children, not too broad then. But the issue is a bit more nuanced than just the word itself being banned. They don't reject a measure just because it uses the word parent. Instead, they ask, is the term clearly defined? Parent, the term parent. Does it create ambiguity about who is affected? Your children, because you're the parent. Could it mislead voters in the title? Parent, the term parent. Could the term parent mislead voters? Wow. Does it sweep in multiple legal categories? Parent, talking about the term parent. In several Colorado initiative reviews, especially around education rights, medical consent for minors, and parental notification laws, the title board or courts have flagged parent when it blurs legal categories. Parent can legally include biological parents, adoptive parents, legal guardians, or custodians, all protected in law. If an initiative doesn't clarify which group it means parents, people taking care of their children. It's vague or could mislead voters about the scope. The term parent, that's what we're up against. That's why we want this amendment, because the title board, in its political activism fashion, is making sure that parent is ambiguous. Creates hidden policy expansion. If a measure says parent but functionally changes rights for schools, like because you want to be involved in your kid's education program, healthcare providers, because at 12 minors cannot consent, and you want to go into the room with your child because you're their parent, custody law. The board may say it actually contains multiple subjects because it impacts several legal domains at once. Your right to be a parent. Makes the ballot title misleading. The word parent makes the title misleading. The title board must write a short, neutral summary. If parent is undefined, they may conclude they can't accurately summarize the measure. We're talking about the term parent. Voters might interpret it differently than the legal effect. They usually don't say parent is too broad by itself. So as long as you're not using parent by itself, then it's not too broad. Bottom line, yes, parent has been treated as too broad in practice in the state of Colorado. Congratulations, parents. As you see your rights being completely taken away, this is another step for this bill to challenge that. And let's talk about the word woman. Yes, woman can run into the same kind of scrutiny in Colorado, but again, it's not automatically rejected just for using the word. Ambiguity in legal woman can be interpreted in different ways depending on context. So parent and woman have been challenged for being too broad in the great state of Colorado. And I'll tell you, my first year here, I ran a great little bill to protect women in sports. I'm getting there, Madam Chair. We brought up initiatives in committee.
Representative Bradley,
Yes, Madam Chair.
let's stick to the amendment.
Absolutely. The amendment is about clarifying language in citizen-led initiatives. We talked about those initiatives in committee. I am bringing it back. Citizen-led initiatives. The title board ruled for my women in athletics that it wasn't single subject, but guess what? I ran the bill in committee. It went through committee, and so I had to go against the big $10,000 an hour lawyer and make sure that the title board ruled in our favor. And we'll get to see that lovely initiative this November. Thank you.
Representative DeGraff.
Thank you, Madam Chair. So yeah, I'm still concerned, but we're talking about giving more power, more authority, more language authority to a group that cannot define woman, which is biologic female, chromosomally XX. It's not hard. Adult. And parent, which is really weird because it's in the CRS. As used in this article, parent-child relationships means the legal relationship between a child and his natural or adoptive parents, incident to which the law confers or imposes rights, privileges, duties, and obligations. Parent and child relationship includes the mother-child relationship and the father-child relationship. Mother-child relationship, father-child relationship. Those two parents, those two biological organisms who created the second biologic organism, person, those are the parents. That is recognized in the Colorado Constitution. And so you have individuals that you want to give more power over the language, over the people of Colorado. that cannot operate inside the basic confines of the language. And so this bill is not just clarifying it. It, at this point, especially when you start rejecting amendments like this to help tighten things up and make it and prioritize the citizens of Colorado over the ideologues of the Gold Dome cesspool, that we need to go back to prioritizing the citizens. So you have an organization that wants more authority over the language that the citizens of Colorado can use in a petition to petition their government for the redress of grievances, and you want to limit individuals who took an oath to support the Constitution, want to limit the ability of the citizens of Colorado to redress their government, to redress grievances to their government. So it's a great amendment. It's a great amendment if your priority is the actual citizens of Colorado and not the machine, not the ideological machine of Colorado. And so when you reject an amendment like this, I can only surmise that your loyalty, that your allegiance is not to the Constitution, not to the citizens of Colorado, but to the ideological machine. I recommend an aye vote on this amendment when we promote the values of our Constitution, that we promote the ability of the citizens to redress their grievances according to the First Amendment, the derivative principles that come from our Declaration of Independence, that our job here is to secure those certain self-evident creator-endowed rights. I ask for an aye vote.
Rep. Garcia.
Thank you, Madam Chair. I just want to, before I begin, I just want to request that we please respect and provide deference to the chair when she is trying to keep us in order. I want to thank the sponsor of this amendment for bringing this forward based on the discussion. We did have this discussion in committee. There was absolutely no commitment to bringing this forward. There was a commitment to continue to think through this. However, in this case, by limiting and reducing the authority that the title board currently has to set the title, under which the Supreme Court has upheld over and over and over and over again, we see that as the, we've seen that in many cases, lending from Say versus Baker, lending from automobile insurance, anyway. We have a lot of case law that basically says that the Supreme Court gives deference to the title board. We also have statutorily that says the title board is supposed to be fair. They're supposed to express the true intent. And they're also supposed to make sure that it's not misleading or that the title is not insufficient. Because of this, and because of the nature and the reason why this whole bill is brought forward, is because the insane amount. I don't know how many of you have actually read 14106. But this is every single obligation that the title board has to consider when they're setting a title. It is so much to consider in a one-sentence question, which is why this bill from the very onset is necessary. If we were to eliminate the expertise of the title board, along with the Supreme Court's continued decisions to uphold this authority for the title board, then we will move away from actually having titles that express the true intent, that are fair, and that are not misleading. Because of this, I ask for a no vote.
Representative Luck.
Thank Thank you, Madam Chair. (140-106). Let's see, 1, 2, 3 pages, 2 and a touch, actually, if you combine, of statutory language. Then you have another 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15 pages of additional notes and considerations, references to cases, explanations, references to laws that have made changes in this space. Yeah, that's quite a bit of things that have to be taken into account in setting the title. But the bill sponsor will note that at the end of this amendment, it contemplates these roughly 18 pages worth of considerations in saying that the title board shall only modify the language used in the draft title to meet the title board's constitutional and statutory duties. Which means nothing in this amendment negates the 18 pages that were just referenced, or any of the court cases that were listed. Because if the proponents of an initiative put forward a title that violates any one of these provisions, the title board has now not only the permission but the responsibility to modify that language to bring it into compliance. Nothing about this amendment suggests that the proponents can willy-nilly decide what to include and what not to include in contravention of otherwise established statute, laws, or case precedent. It simply says that if the proponents want to go through the effort, in the same way legislators do in drafting their bill title, their referendum title language, and satisfy every single one of these elements, and they propose that to the title board, and all of the boxes are checked, nothing is violating any of the standards that the title board has to revolve around, the title board needs to take that language. And you'd think that the title board would be grateful for that. Because the individuals who serve on the title board don't just serve on the title board. They have other tasks and duties connected to the other jobs that they do. And so you would think that relieving them of some of their responsibilities, taking the burden off them of trying to figure this complicated language out, would be a welcome reprieve. No one is suggesting that we violate the Constitution and its idea of setting the title. Ultimately, the title board will still set the title. They'll take that draft language and say, yep, meets all the things, good to go. This is the language we're using, set. And if we in this building have the right to nuance our words, to properly structure our questions, to ensure the greatest degree of success, then in fairness, we should afford those initiators the same respect. Again, there is nothing that's violating. In fact, it points back to this section and to these requirements. They must modify the language if the draft does not meet the title board's constitutional and statutory duties. I continue to ask for an aye vote, and I appreciate the conversation.
Rep. Garcia.
Thank you, Madam Chair. I, again, rise and ask for a no vote on this. I look at this and I automatically think, just given the constitutional obligation that exists within the title board, the continued, Supreme Court rulings that uphold the duties of the title board. The title board's responsibility is to set the title question. It's not simply just to modify. Proponents already come with a draft question. They already sit down and engage in conversations in a public space, back and forth. They can do this once, twice, 3 times. They go through the title board setting with the title board. They are sitting there in the room, discussing and engaging and choosing literally word for word what should be in the title question. Taking away the obligation of experts who are trained, who know how to review a title question against all of regulations around it, would set us up for even more unconstitutional questions that make the ballot. I ask for a no vote.
Real, 1 second, Rep. Bradley. I just want to say that I want to ensure that we stick to the language in the amendment, and this is not the time to talk about or challenge definitions that have already been challenged. And so I would ask that we would stick to the wording on the amendment, and for those of us that are coming to speak, we accept and respect respectable dialogue, and this is where that happens, but let's just stick to the amendment, which is title in a logical and readable order, and keep it there. Thank you. Rep. Bradley.
Thank you, Madam Chair. This amendment is not unconstitutional. Like, give me a break. We're not going to bring unconstitutional amendments. We're asking for clarity for citizen-led initiatives. And when you say that title board is full of experts that can't even define a parent or a woman, I disagree completely. Thank you.
Rep. Bacon. AML Bacon.
Thank you. I think what I'd just like to add to this is whether or not we question if this is constitutional. For what it's worth, we have had those questions on amendments before, and we've all gone to the side to rewrite them if that was the case. But the thing that is striking to me is just trying to understand what the statement is around the presumption. I don't believe that presuming that the title is sufficient would actually eliminate the burden of the vetting of the title. I think we would still have attorneys look at it. I think we would still have our constitutional tests being asked. And so for me, when I see this, I am curious if the presumption is that a title would automatically be accepted if we also presume that the work to vet it wouldn't happen. And if that is the assumption, I don't believe that's the assumption, right? And so I'm not sure why we need the presumption if we know the work is still going to happen. And so that's my take on this. In regards to some of the policy issues that we heard, I don't think they still wouldn't ask those questions. And so I think I just wanted to offer that because I can understand what I think I'm hearing, but I just want to be clear on what we expect to happen with this presumption that wouldn't still already happen by way of vetting these titles and to vet the titles not only for statutory language or constitutional concern.
Representative Bradley.
Thank you, and thank you for listening. So our problem is that there is 2 types of models or regulations. Legislator-driven are not going to go through this, and citizen-led are now being legislated even more. So we're trying to look for clarity. And what I had set up here, and I'd gotten a little bit of trouble, I don't even know why, is that I ran a bill that the title board deemed not under single subject. But my bill went through committee, so it was single subject, because in this body, we have to have our bills deemed single subject. So I already have an example of what these experts have done, and then it delayed a citizen-led initiative by 8 weeks through attorneys that they were paying for that these citizens could not afford. And I had to skip out in here and go up there and say to the title board, why did the General Assembly rule my bill single subject, but you are making these citizen-led initiatives not go through it because you're ruling it against single subject? So we're just trying to clarify so that legislator-driven initiatives have to jump through the same hoops that we're going to now make the citizen-led initiatives.
Rep. AML Bacon.
Thank you for that. I think, though, what my question is even if they presumed it was single subject, they would still vet the title. And that's why I'm asking again for the clarity about what the presumption means. Are we saying that, this is hypothetical, I don't know if this is, but are you saying that this presumption means they won't vet it or they have different burdens of vetting? But even if they had a different burden of vetting, it doesn't mean that these questions still wouldn't be raised. And that's what I'm trying to understand. So can you articulate what this presumed sufficient means by way of the work of vetting?
Representative Luck.
Thank you, Madam Chair, and thank you, the representative from Denver, for asking that clarifying question. I think it's important. So as the initiative sponsor, or not the initiative, the amendment sponsor, I will say it's not my intention that there not be a vetting process. I think, sorry, lots of conversations. It's good. It's good that there's discourse in this building. It's not that there is a desire to circumvent any vetting at all, right? My intention in this is to say, when these folks come together, when you have the title board members and you have the initiators and they come together and the initiators have gone through the process, right? Because the first line says the proponents of a proposed initiative may submit a draft title in advance of the title setting meeting, in advance. So the idea in my mind is that if the initiators, and I would look to, but it just feels odd, if the initiators go through the process of providing draft language. They don't have to, but if they do, and they say, this is so important to us that we want to be able to frame our own issue, and they come up with language, and that language is submitted in advance to their meeting, and the title board looks at that draft and looks at 140, 106 and says, needs to have 10 commas, 10 commas, check. Needs to have capital letters, check. Needs to include the phrase underwater basket weaving, check. Whatever those standards are, and at the end of the process says, yep, check, 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 all is there, that they have to presume that then sufficient, that they should be able to take that draft and say it meets all of our requirements, and so we're not going to change it. Because I can't change the Constitution that says the title board shall set. So I can't say in consultation with or through agreement with. Like I can't require that the initiators and the title board sit together and reach a point of agreement, right? Because of the different. But I can say, hey, title board, when you go to set this title, and if the title or the initiators provide you with language and it satisfies all of your requirements, take their language. Presume that to be. And maybe it's not the right word to say presumed sufficient, right? Maybe there's a better way to nuance that to say, that the proposed initiative is sufficient unless the title board finds or something. But the idea behind what is trying to be accomplished here is that if those members of the public who go through all of this heartache come to the title board and say, this is what we think is the language that will give us the best chance of success at the ballot box, and it satisfies all of the different legal requirements, then take that. Don't change it, right? And I think what Rep. from Douglas County is pointing to is a feeling within certain circles in Colorado that the title board on occasion is opposed to certain things, such that they challenge different aspects, and then it leaves people feeling like they're not actually getting the fairest of chances. And so if we can minimize that, even if it doesn't exist, right? But her example is questioning. Why is a bill that was single subject here determined not single subject in another forum? And so there is some of that frustration, and why is it that legislators get to decide what their ballot title language looks like and we can't? And so to have some degree of parity, that if they go through all of that work and they satisfy all of those requirements, which it has been laid out clearly here, is nearly impossible, that we then honor that work and honor their request and give them the best shot they can at election time.
Amel Winter.
Thank you, Madam Chair. And if my memory serves me correct, I think there was an issue that we had last year when we were working on the Blue Book, and there was a vote taken. And I think that it was a clarity issue. And I agree with my colleagues, and when we're looking at some of these issues, we do need to be clear for the voters, because there's so many times that I talk to voters after the vote, and they're like, we didn't understand the language, or it was vague. And I just know that I'm pretty sure some of this is born out of a conversation we had with the approval of the Blue Book last year, and it was around, I think, the Prop KK stuff. And there was a disagreement on some language. The proposed language failed, the language that we already had in the Blue Book. But I just want to put on the record that, you know, I think that what the initiative is going to do needs to be very clear. And I think for the voters of Colorado, it's only fair. And I don't think it's a partisan issue. I think it should be ultra clear for people so they know whether they're voting for a tax increase, they're voting for a tax decrease. So many times, we all know how busy we are here, and we know how busy life is. And I just don't want us to put hurdles in front of the citizens being able to redress their grievances with the state of Colorado. So I just wanted to put that on the record. I think that this is kind of born from some conversation that happened in that around clarity of that issue, and I just wanted to share that with you since you weren't in the building last year.
Representative DeGraff. To the amendment.
Thank you, Madam Chair. And just to address that regarding the amendment and the clarity of the language for the citizens who are wondering about the Blue Book, if it's in the Blue Book, it's a tax increase, right? You don't even have to worry about the clarity of language. If it's in the Blue Book, it's a tax increase. If it's a tax decrease, which never happens out of this room, it would not need to be in the Blue Book, right? You'll never see a tax decrease out of this room, but if it was, it wouldn't be in the Blue Book. We could just do it. So tax increase, Blue Book, it's a tax increase.
Is there any further discussion on amendment? Seeing none, the question for a division has been called. We will go into a brief recess. Get out of here. Oh. The committee will come back to order. The question before us is the adoption of Amendment L004. A division has been requested. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor of Amendment L004, please stand and remain standing in one place or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place or raise your hand and keep it raised until the count is taken. Okay. You may be seated. Amendment L004 is lost. Is there any further discussion? Well, no, the amendment is lost. Is there any further discussion on Representative Luck? And this is now to the bill.
Thank
To the
you.
report, still to the report. Okay.
Thank you, Madam Chair, and thank you, committee, for engaging in that conversation. I very much appreciate it. I move Amendment L003 in hopes of having a bit more success on this front.
To the committee report. We are still to the committee report. Representative Luck.
Thank you, Madam Chair. You'd think that this was my first day in the building. I withdraw that amendment and wait in anticipation for bringing it back once the committee report is adopted.
All right, the question before us is the adoption of the committee report. All those as Representative McGrath. Sorry, I didn't see.
Madam Chair, I feel like you were deliberately looking in the opposite direction.
Let me get the gavel. To the committee report, Representative DeGraff.
Thank you, Madam Chair. This is, in fact, to the committee report. It's been shared with the sponsors, and I ask L005 be moved. I move L005 to House Bill 1320 and ask that it be displayed. I am moving it to the committee report for House Bill 1320.
Amendment R005 is displayed. Representative DeGraff to the amendment.
Thank you, Madam Chair. So what this does, and it goes to what my colleague brought up about Blue Book language. And of course, anybody that puts something in the Blue Book, and again, for everybody listening at home, if it's in the Blue Book, it's a tax increase. It is a tax increase. If not now, it's a tax increase later. Now, what happens in these Blue Books is the people that are proposing them, the people that have brought it, they want to obscure it so you don't realize it's a tax increase. But by nature, being in the Blue Book, it's a tax increase. So what this does in the committee report and in the bill, this is a hybrid, you'll notice, and this was done, I think it was in 1126, and it's the drafter's discretion because it makes sense. There's parts of both. We're moving the amendment. It modifies the committee report and it modifies the bill simultaneously. So it's just an efficiency matter. But what this does is it keeps mandatory tax impact warning at the front of the title. Because it sure seems that a big reason for having this bill come forward is that we're going to be trying to hide language. So what this does is it takes everything where it just reverts it to current law and takes out anything that would be basically striking out which may appear anywhere in the ballot title, which may be placed anywhere. So why would the bill that is supposed to be around these ballot titles, looking for clarity, why would the language specifically, why would it go from our tried and true, where we put that tax language up at the front, without raising taxes, it's a tax increase, or by with increasing taxes, and then putting it later in the sentence or anywhere else in the description and hiding that? I mean, I know why there's the desire to obfuscate the purpose of it. So what it does is it strikes the phrase which may appear anywhere in the ballot title, strike the phrase which may be placed anywhere in the subsection, substitute language requiring the mandated taxing statement to appear at the beginning of the ballot title or immediately after the Tabor language when in Article X or Article 10, Section 23C applies. So the rationale is that the bill's core negative move is giving the title board discretion to relocate tax impact warnings, which is generally a primary reason for being a ballot initiative. So the bill's core negative move is giving the title board discretion to relocate tax impact warnings. Restoring the prominent placement preserves voter notice and limits discretionary softening of fiscal consequences. It's easy for me to say. Challenging druthers. Challenging for others. Easy for me to say, challenging for others. Fiscal consequences. This would improve, this would reduce state discretion and preserve clearer disclosure. So again, yeah, maybe we need to update the title board, but maybe the purpose of the bill in the modification of the language, especially when you take it and you take this and you say, well, the tax implications of this, which are only required to be revealed to the citizens of Colorado by the Taxpayer Bill of Rights, which is under continual assault in this room. So the underlying, so one of the things that we do with amendments is that we say, let's put an amendment forward and then we'll find out what the real purpose of the bill is. So this language that says the tax implications can appear anywhere in the ballot title, at the very end, somewhere in the middle where we deem it's not going to be as clear. So those, let's just say that type wording was added inadvertently to give flexibility. But if we reject it, what we can know is that was the intent of the bill. I don't know the motive, but if we're going to keep which may appear things like which may appear anywhere in the ballot, which may be placed anywhere, what we're trying to do is we're trying to bury the consequences of the initiative. And I think that is a disservice to the citizens of Colorado.
System Majority Leader Bacon.
Thank you, Madam Chair. And I have a question for a colleague from El Paso County. I'm trying to understand what your issue precisely is. From what I understand about the amendment, you would like to then so if I look at lines 2 and 3 in the printed bill, it says amend 3B, 3E, 3F, 3G, and 3H. You would like the bill to just then amend 3B and 3H, not 3E, F, and G. Okay? Then as you spoke about 3E, is your issue the language in 3E that you want struck, or the whole subsection, do you want that struck from law?
Representative Luck.
Thank you, Madam Chair, and thank you again to the representative from Denver for having this conversation. I also am processing this amendment in real time, but I think if I understand correctly, this has to be to the committee report. This particular set of amendments have to be to the committee report because the committee report added in additional sections. And those sections, if we delete this one, will not be numbered or lettered correctly. That's what my reading is on what's going on here. And so it's my understanding that the amendment sponsor is trying to strike the language that changes the Tabor standard for how we present ballot initiatives that deal with either revenue or expenditure changes. But he obviously can speak for himself.
Representative Garcia.
Thank you, Madam Chair. I just want to clarify that the language that they're trying to strike is not actually Tabor standard language, as it wasn't implemented into the law until 2021. Thank you.
Representative Luck.
Thank you, Madam Chair, and thank you for that tidbit of information. I am grateful for that. You know, always nice to have some of those details. Just, I will say, while it may not come strictly from Tabor, there is the same. It is the money. It's all about the money, folks. All about the money. So it's that section.
Representative Nguyen.
Thank you, Madam Chair. I rise in opposition to this amendment because one of the core aspects of this bill is to make sure that ballot accessibility is enshrined in our bill. Currently, 1320 allows us with our amendment process to allow that language to be anywhere in the question. What this amendment does is that this basically reframes it so that that language goes back to the very beginning. The goal of 1320 was to make sure that ballot accessibility is that it doesn't have to have that Tabor statutory language in the very beginning. The goal has always been to make sure that that understanding, clear, concise language can go within anywhere on the ballot, so to speak. So we urge a no vote on this amendment.
Representative DeGraff.
So it's always been at the beginning, but it's not required to be at the beginning. So we're going to remove it and say that it can be anywhere. But if we strike that, if we strike that, we strike these large cap letters, which is, again, the intent of the bill, and this is where our amazing drafters go through to find these, say, this is what I want. What I need to do is I need to strike the phrase, which may appear anywhere in the ballot title, and which may be placed anywhere. And then somehow, these magical people called drafters, they find all of this and how this I would be missing both eyes at this point if that was my requirement to track all these down. But that's what the intent is. And basically replace it with which must appear at the beginning of the ballot title. So what the drafter did was just remove all of those areas where it says may appear anywhere in the ballot title and may be placed anywhere. And what that does is it returns it to initial statute. So when when the sponsor says, well, the intent of the initial statute was that it could be anywhere and we're just clarifying the initial statute, I would argue no, because the initial statute clearly puts that tax wording at the beginning of the initiative, of the title, telling you up front what this is. So this language in here, this all caps language, such as which may appear anywhere in the ballot title, that is new. The all caps is new. That's on page 3, line 16, for those of you following at home. That is new. That is changing the original intent. If you don't want to change the original intent, don't add something that's in all caps. So easy right now. You want to go with the initial intent, and we only want to make some small changes? This is a large change. This is a substantial change. This is a deliberate change, and this is a deceptive change. I don't know why. Well, when you take...
Representative DeGraff, can you keep it centered to the amendment you brought and keep the conversation there, please?
Well, the reason for moving that language about the tax implications to anywhere in the ballot title, or anywhere, is not for the purpose of clarity, is not for the purpose of understanding, and is certainly not for the purpose of informing the people who look at that ballot title and they make largely a determination. So I would say the reason for removing it from that is so that the people who start reading it and go, wow, this legalese, this obtuse legalese, I'm not going to be able to make it through this. And then they stop reading. And so what the title people would like you to say, what they would just like it to lead off with is for the children, for example. For the environment, for the purpose of all this stuff. And then they want to take that tax part and they want to put it, and they want to bury it someplace in the title. So if that's not the case, we accept this amendment, we go back to the original wording, we go back to the original intent, because we're talking about a ballot initiative that, according to the Taxpayer Bill of Rights, is a substantial change in tax code, or it is a tax increase. And so if the purpose of it being in the bill, or that it has a tax increase in it or a substantial change to the tax code, if that is the purpose, then the purpose needs to be brought out up front, not hidden behind for the children or for some emotional bait that will get somebody to bite down on the hook of raising their taxes on themselves. The purpose, and I'm not, motive? I don't know. What's the motive? What's the motive? The motive would be to hide that. The motive is to hide that. I'm not questioning the motive.
Representative DeGraff.
Yes.
Can you please not impugn motives against your colleagues in suggesting that this is something they're trying to do in this particular policy, and just stick to your amendment and the language that you would like to see struck and keep it there? Thank you.
Okay, well, I guess this gets to language and the use of language, because impugning motive would be to say that it's wrong or something. And no, I just said. I said deceptive.
Representative Graff, can we
I'm
please
getting
talk
a
about
sidebar
the
here.
amendment?
I'm getting a sidebar here, so I'm honoring my colleague. There is a matter of statement of fact. I am speaking in terms of statement of fact. If you bury, okay, let's just go back and let's make sure we take any implication of motive out of this. If through no intent of the sponsors, you take that language that says it's related to the tax code, and you remove it or you move it into someplace else that it can be hidden, through no intention of the sponsor, that title becomes deceptive. Through no intention of the sponsor. It's just the happenstance of, it's just a result of that action. It makes it more difficult for the citizen to read that blue book and understand what they're looking at. So what I'm saying is, if you don't want to inadvertently create deceptive titles, then what we do is we remove these changes, which were clearly unintended, and we revert back to the original intent that says if it's going to be in the ballot title, if you're going to do a ballot initiative, you don't inadvertently create a deceptive title by allowing that wording to be moved someplace else inside the title. So I'm not questioning the motive of the sponsors. I'm just trying to help them make sure they stay inside the bounds of what they're trying to achieve. And I know they're trying to be not deceptive, but the result of the language in the bill would make for deceptive titles. And that's just a statement of fact. So in order to help the sponsors maintain their intention of being non-deceptive, I suggest a yes on this amendment, so we stay away from deceptive titles inadvertently, and make sure that our titles are not deceptive by going back to the intent of the law. Because otherwise, we're really kind of actually changing. You're doing multiple subjects here. This wording in itself would be worth a whole discussion, which I guess is what we're doing. But in order for there not to be inadvertently deceptive titles contradictory to the sponsor's intent, I recommend an aye vote.
Representative Luck.
Thank you, Madam Chair. I rise in support of this particular amendment. Deception is a strong word, so I think I'm going to choose the word fair. This goes back to my first amendment, where I talked about how when folks see their ballot and they come and they talk to people like me who they think has a better grasp of these issues, and they get to the questions that start out, shall there be a reduction to state sales tax? Or shall there be an increase to state sales tax? Many of them, in my experience, stop there. They don't read further. They say, no, I don't want a reduction. Yes, or yes, I do want a reduction. No, I don't want an increase. And that informs their vote. And the concern that I raised in the last amendment that was not brought is if we're going to do it this way, because again, I agree with the underlying premise of this bill that we need to have clear ballot titles, that if we're going to do it this way and we're going to reconfigure it in this fashion to allow for this language to be put anywhere in the ballot language to facilitate readability, that we should allow the citizens the opportunity to frame it. But as you know, that was defeated as an idea, and so now we're left with that same issue of what happens when the title board receives 4 titles, 2 reductions, 2 increases, and they do not have the same construction. Whether it began in 2021 or well before, because I have some ballot language here, and that's for a different conversation, but I have some ballot language here from 2013 that talks about taxes from the same kind of framework. Shall state taxes be increased by? People have come to expect that that particular language is at the beginning when there is a fiscal impact of any particular question. And so what happens when the title board puts that language at the beginning for readability purposes on 1 tax increase and 1 tax reduction, and somewhere in the middle or the end for the other 2 initiatives, and the ballot goes out, and the 2 where it was at the beginning have markedly different results than the 2 at the end, even if polling and such would suggest that they should be pretty well on par. Are the citizens going to be left feeling like they were given a fair shot at the electorate? Or are they going to feel like the title board tipped the scales? Framing a question is very powerful. The first story always sounds right. Proverbs then until the cross-examination starts, but on ballots, you don't tend to get a cross-examination time. You get the first story. And those first few words are often very dispositive. It's no different than voting for candidates. Why do people want to be the top name on the ballot? Because they know that has a greater likelihood of success.
Representative Luck, is this to the amendment?
It is. Thank you, Madam Chair. Thank you for seeking clarity. It is, because this amendment is all about whether or not we allow the title board to use different standards and different ones under the guise of readability, and thereby have the potential of influencing an outcome for an election in an unjust way. Whether they mean to be unjust or not, could just happen. So I rise in support of this. I tried to avoid this particular part of the conversation by presenting the other amendment and saying, hey, give the people who submit it an opportunity to make their own language. And if it satisfies constitutional and statutory muster, use that. And then there won't be any opportunities for people to cry foul. But that was shot down. So here's the next best solve to a very real problem. I ask for an aye vote.
Representative DeGraff. To the amendment.
Thank you, Madam Chair. I just wanted to clarify my earlier discussion on the amendment because of the word deceptive. Deception is the act of deliberately causing somebody to accept something as true that is not true. It is an action that hides the truth. There's no motive discussed in here. There's nothing about deceptive that's motive implying. You might deceive your dog into taking some medicine by putting it in some bacon or something. That's not negative. Dog loves it. He needed the medicine anyways. Now I got bacon.
Representative DeGraff.
Sorry.
To your amendment, please.
It's just an interesting analogy. Okay, so there's nothing motive implying about the term deceptive. It just means that if you take the wording about the tax increase and you bury it someplace inside the title, or you bury that description someplace in the bill, like towards the bottom, or someplace that somebody's not going to remove, what you've done or what you're leading to or what you're availing is that you are creating the opportunity for a deceptive title. You're a deceptive ballot title. You're creating the environment for a deceptive ballot title. Now, if creating the environment for a deceptive ballot title is not the intention of the sponsor, then this is an easy amendment. It just goes back to making the ballot title clear. Now, if it is the intention of the sponsor to create a deceptive ballot title, then the sponsor will reject this amendment and will change and will alter the CRS in the direction of the ability to create, because it certainly doesn't say it has to be someplace else. It certainly allows that it could be at the beginning. So I can't say that will always happen. But the options here are, and I don't, without speaking to intent, the options are to accept the amendment and remove the opportunity to create a deceptive ballot title and a deceptive ballot description. Or you reject this and make it plain that your intent, without motive, is to create the environment for a deceptive ballot title. So the choice is clear. The choice is clear in terms of whether you want to create the environment for a deceptive ballot title and a deceptive ballot description, or you want to remove that opportunity for a deceptive ballot title. So I think my estimate is that the sponsors really don't want a deceptive ballot title, and so that they will accept this amendment, which is purely for the sake of removing the environment whereby you would have a deceptive ballot title. Because if the sponsors reject this amendment, they are stating their intent is a deceptive ballot
Representative
title. That has
DeGraff.
nothing to do with motive.
Representative Bradley.
Thank you, Madam Chair. And I would agree with the term. When we are promised that there will be an amendment to make sure that citizen-led ballots are the same as legislator-driven ones, like the amendments we brought forward, then this is what happens. There was an amendment brought forward. In closing comments, it was said that we need the citizen-led initiatives to be very similar to the legislator-driven initiatives. I wrote it down on my piece of paper. Okay? We've had a 30-year tradition of this particular language. 30 years, we have gone to the voters with this particular language, and now because there was a proposition that seemed to hurt feelings the way it was written, we now have this bill coming forward. Since Tabor was passed, we have voter expectations. That's why the voters will not get rid of Tabor, thankfully. This amendment is to make sure it's clarified the way that the past 30 years, we can talk about clearing up the language. That is not what we're upset about. We're upset that there's two different standards. That's what we're upset about. We're upset that 30 years of language driven in these initiatives have been the tradition. And now we're upset that the voters didn't like that. And that's why we're going to continue to argue. We're going to continue to argue till our point is made, until there's some bipartisanship in this. So I'll start reading the bill at length if I have to.
The question before us is the adoption of Amendment L005. All those in favor say aye. Aye. All those opposed, no. Amendment L005 is lost. Representative DeGraff.
Okay. So now we know the intent of the bill. Not motive, but the intent.
Representative DeGraff, please do not suggest intent of a bill because an amendment was not accepted. Can we please just keep it? Now we're still on the committee report. Thank you.
Absent intent or motive, the result is creating an environment for a deceptive bill title. So let's try this again. I move L006 to the committee report for House Bill 1320 and ask that it be displayed.
L006 is displayed. Representative DeGraff to the amendment.
Amend the State Civic Military Veterans Affairs Committee report. Keep hand me my iPad. Thank you. After line, page 1, after line 11, insert does not omit material, fiscal, regulatory, or legal consequences of the proposed law or constitutional amendment. So we're going to insert this language to clarify what we're intending. And so what this is doing is it's adding a neutrality guardrail to the new accessible language standard. So when we create this and we say, well, we're going to have a new accessible language standard, what we want to do is we want to make sure that this accessibility standard, this subjective language that is being foreseen in this bill, does not omit material, fiscal, regulatory, or legal consequences of the proposed law or constitutional amendment. Now, that is just not to speak to intent, but that is just to put a neutrality framework in there so that some bills are not just like, well, we didn't think that was important. We just didn't think that was important to include, and so we left it out. The bill title was too long, the financial implications were too confusing, and it's for the children, so we left it out. It's always for the children. So that's another thing. If it says it's for the children, it's not. So we're putting some neutrality boundaries on here, and we're saying that it does not omit material, fiscal, regulatory, or legal consequences. If you're going to vote on something, there's a pretty good idea, there's a pretty good expectation, I think, that you're going to want to know the consequences of that ballot initiative. I mean, that's why you're voting on it. That's why it's brought to you. You are saying that you accept those consequences. You accept that raising of taxes. You accept that additional regulation. You accept that restriction on your liberty, and you accept that assault on your pursuit of happiness, property, prosperity. Whoops. Inadvertent. And then the same language on page 2 after line 6. Again, we're committee report. This is a hybrid. This is in accordance with the discretion of the drafter. Does not omit material, fiscal, regulatory, or legal consequences of the proposed law or the constitutional amendment. Does not use persuasive, emotive, or advocacy-oriented language. Because what the bill titles were is they were objective. And now in terms of this bill, what you're taking is the objectivity out. And yes, the objectivity probably makes it a little bit more, but this is basically you're talking about, you're making a contract with the citizens, and it has very specific language. So if you read a contract is going to make sure that you have the actual language and that you're not inserting persuasive, emotion, or advocacy-oriented language. We're only dealing with the material, fiscal, regulatory, and legal consequences of the proposed law. So what this is, again, is this is a neutrality guardrail. L002 defines readability factors, but it does not expressly bar slanted phrasing or omissions of consequences. This amendment converts accessible language into a neutral readability rule. And we're fine with that. A neutral readability rule is fine. Maybe the language is a little bit too, the example that was used in the committee was taking the language and using AI to create bring the reading level down from Ivy League graduate in law to high school level so that everybody can read it, and that's fantastic. But what it did not do, and what we want to make sure that we're doing is we don't take that readability rule and we leave out the neutrality guidelines, guardrails, and create a discretion expanding tool. So the intent, concerning statutory requirements for battle title language and connection therewith, requiring the use of accessible language and allowing for modification of statutorily required ballot title language. Okay, that was the last amendment, statutorily required ballot title language. So what the bill seems to be doing, at least by the title, I'm not sure if the title speaks to the intent, but the title is about allowing for the modification. Modification, I suppose, would include removal of statutorily required ballot title language. Or if not removal, that it allows the modification of it. It allows it to be shaped. So again, this amendment is simply for a neutrality guardrail. We agree with the sponsor's stated intent, not of the previous amendment, but we agree with the stated intent of making these more readable. But in making them more readable, they can't become less clear or less honest. And this neutrality guardrail just says, does not omit the material, the fiscal, regulatory, or legal consequences. So it's just saying it does not make sure that you describe the consequences of this bill to the people who are going to be voting on it. Yes, of course, it's for the children. But how much are they going to pay for it? That's what they want to know. Because they have to make those decisions, and you have to have, in order to make a proper informed decision, informed consent, you need to know the cost and you need to know the benefit. And this just makes sure that the citizens actually are told the cost. And again, if the sponsor's intent is to not include the cost, not make sure the citizens of Colorado understand the consequences of their vote, then they'll vote down this amendment. If the sponsor's intent has all along been that there was never any intent to remove any regard for consequences, then the sponsor will accept this amendment. So we'll find out the intent of the sponsor.
Representative Nguyen.
Thank you, Madam Chair. I rise in opposition to this amendment because, for one thing, in Section 2 of 1320, we have a clause in lines 21 to 27 that indicates that the understanding of the effect is a yes or no, or a no and against vote. And this idea that we're basically addressing the confusion of misleading titles already. Our bill is already addressing that, and we are not going to omit or have any persuasive or motive advocacy language already. So I feel like this amendment just doesn't really fit in with the setting already, because we're already doing that. We're already advocating and making clear, accessible language. The goal of the bill title is yes or no. It is not to debate about discussing about fiscal regulatory policy. because the intention already is to have that in the ballots. So again, appreciate your time. Thank you so much.
Representative DeGraff.
And I appreciate that. I missed the reference, but I'm looking at are in the form of questions that may be answered yes or no. To vote in favor of the proposed law or question or amendment, no against. I'm just saying that in order to make an informed decision, make the idea of informed consent to something, you need to know. So this just making clear, if you're saying that it already in here, making clear that the bill does include the language that says, so when they're going to make this yes-no decision, when they're going to make that decision of yes or no, I want to subject myself to this tax increase, that they understand the consequences of it. Yes or no, do they want not do they want the outcome of the tax? Do you want to feed the children? Oh, the answer is yes. Do you want to feed the children with half of your discretionary income? Some people might say no. They need to know for full consent, they need to know the cost and they need to know the benefit. That's all this does. That's all this does is ensure that they understand the cost, the consequences of their yes-no vote. I appreciate that the ballot is written in a way that they understand that it is a yes-no vote, but in order to have an informed yes-no vote, they need to know the consequences of that vote. Otherwise, they're voting on something partial. Do you want this to happen? Yes. Do you understand the consequences of that? That's all this does. This would keep that in there. It's a neutrality guideline.
No.
It's not an attack on the bill. Because I recognize that with some of the ballot questions with the double negatives and all that, it is very difficult to figure out. And so to be able to, that you have to go through and make sure that you can answer that question yes or no. But the only way you can answer that question yes or no is if you understand the consequences of the bill, of the amendment, of the ballot title. So it's not an attack, it's trying to help clarify this. The citizens need to know the consequences if they're going to make an informed decision. I don't really see that those consequences are delineated here in the bill. Again, we only found out about this bill being on the calendar at 8 o'clock this morning. So the time to address some of these issues is a little bit limited. It would be nice to have some more time. But we found out about it at 8 o'clock this morning, what's in the queue. So what we're doing is just, again, it's a neutrality guideline. This bill does not ensure, I don't see anything in the bill that ensures that the consequences are addressed so that when the voter votes yes or no, that they actually have had the chance to understand the consequences. So if you don't want them to understand the possible consequences of their vote, then you vote this down. You don't want them to understand the consequences of their vote. If you want them to be very clear about the consequences of their vote,
Representative
then you vote
DeGraff,
yes on this
let's
amendment.
just stay to the intent of the amendment, not suggesting how someone's vote, what the outcome would be. Thank you.
Well, that's the purpose of the amendment. The purpose of the amendment is to clarify whether the citizens will be notified of the consequences of their vote. So a yes vote, for those voting on it, a yes vote is you want the consequences to the citizens to be known. A no vote is so that they don't necessarily know the consequences of their vote. That's all. That's what the amendment is. And I'll ask for division on it and I'll cow it.
The committee will go into a brief recess. The committee will come back to order. The question before us is the adoption of, I'm sorry. Brett. The committee will go into a brief recess. The committee will come back to order. Representative Bottoms.
Thank you, Chair. As I mentioned earlier when I was discussing an amendment, I did mention that I have a little bit of problem with the bill, and this amendment highlights that problem. And that is that we already see, so again, I agree with the bill sponsors. Our language of our bills is crazy. There's no doubt about that. We're one of the worst states in the United States when it comes to our bill language, no doubt about that. But I want to make sure that there's not a door that's open inadvertently or however that says that in the process of trying to make this simplified or simplistic or more easily understood, which are all very good, very important, that we don't open the door for language that can be deceptively emotive, or even logistically deceptive of how the bill is going to work, what's going to happen. And so I do believe that this amendment is necessary. I think we can actually accomplish the heartbeat of the sponsors with this amendment. We can actually get there and make this bill something that really is, at the end of the day, it really does make the language easier, but it also doesn't hinder or hurt the voter that is trying to figure out what the language actually says. And so I still don't think this is a bad bill. I just think it's got some glaring deficiencies. And this will fix, I think will fix one of the biggest deficiencies, and could be the only one that I would say, okay, if we fix this, maybe, I can get behind this and vote for it. And I don't say that tongue in cheek. I'm not saying that politically. I really am saying I do like the idea of this bill. We need to fix this. This is a problem in our state when it comes to ballot initiatives. But it's leaving too many doors wide open, and so I do strongly urge an aye vote on this, and to try to figure out how we can do this together, bipartisan. I know we throw that word around, but try to figure out how to do this together so that we can actually have good language on our ballot initiatives, something that somebody can read, quickly understand the initiative, but not also be deceived by language that maybe a drafter of the initiative might want to try to use to manipulate or intimidate. And so, yeah, let's try to get this bill passed. Let's do it with this amendment. And I do think this is the path forward. So I urge an aye vote on this amendment.
The question before us is the adoption of Amendment L006. A division has been requested. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor of Amendment 006, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place or raise your hand and keep it raised until the count is taken. You may be seated. Amendment 006 is lost. Majority Leader Duran.
Thank you, Madam Chair. I move to rise, report progress, and beg leave to sit again on, March 25th at noon.
The question before us is whether the committee will rise, report, progress, and beg leave to sit again later today. All those in favor say aye.
Aye.
All those opposed, no. The ayes have it. The committee will rise, report, progress, and beg leave to sit again. The House will come back to order. Mr. Schiebel, please read the report of the Committee of the Whole.
Madam Speaker, your committee rises, reports progress, and begs leave to sit again.
Madam Majority Leader.
Thank you, Madam Speaker. Pursuant to House Rule 14, I move that debate on House Bill 1320 be limited to 1 hour during special orders on March 25th, 2026.
The motion before us is pursuant to House Rule 14 that debate on House Bill 1320 will be limited to 1 hour. This is a non-debatable motion pursuant to House Rule 15E and requires a majority of all members elected to pass. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Camacho and Rootnell, Zokai, all excused. Please close the machine. With 36 aye, 23 no, and 6 excused, the motion is adopted. Representative English. Oh, Assistant Majority Leader Bacon.
Madam Speaker, I move the House now resolve itself consideration of special order. I'm sorry, to continue the continuation of special orders.
Members, you have heard the motion. Seeing no objection, AML Bacon will take the chair.
Come to order. With your unanimous consent, the bills will be read by title unless there is a request for a reading of a bill at length. Committee reports are printed in your bill folders. Floor amendments will be shown on the screen on iLegislate in today's folder on your box account. Bills will be laid over upon motion of the majority leader, and the coat rule is relaxed. Members, we are still within debate on House Bill 261320. We have an hour for debate. Okay, we are still to the committee report. Representative DeGraff.
Thank you, Madam Chair. It's great fun to serve with you. Okay. So since we haven't voted on this, I guess we have, but again, on the committee report, I think we're actually done with this one, aren't we? Or are we still talking to this one? We vote not to the committee report.
Okay. So discussion is to the committee report. Is there any discussion on the committee report? Okay, Representative Garcia.
Madam Chair, we asked for an aye vote on the committee report.
Seeing no further discussion, the question before us is the passage of the committee report to House Bill 1320. All those in favor, please say aye. Aye. All those opposed, please say no. No. The committee report is adopted. To the bill. Representative DeGraff.
Okay. The First Amendment has left the building.
If that's the case, please sit down. No, I'm kidding. To the bill.
Well, we're talking, Madam Chair, about the right to petition your government. And we've been petitioning the government. We're talking actually about the First Amendment and petitioning the government. And we're talking about removing the potential and not creating the environment for persuasive, emotive, advocacy-oriented, or deceptive speech. Those have all been voted down. So now we have a bill before us that, regardless of intent, has intentionally created the environment for persuasive, emotive, advocacy-oriented speech. Non-neutral, subjective language to be put before the citizens of Colorado for the purpose of tax-tracting them more. Ever more. And this is important because there will at some point be a vote on the Taxpayer Bill of Rights, because it is an affront to the majority party that the taxpayers have rights. So in this effort to recover this bill, which now we know is written for the inclusion of persuasive, emotion, advocacy-oriented language. I don't know why, because it seems somebody who is a voice of the people would want to make sure that the people they represent would understand the consequences of their actions and not have that buried in persuasive, emotive, or advocacy-oriented language. So we'll try one more time and I move L007 to House Bill 1320 and ask that it be displayed.
Give us 1 second. All right, the amendment is displayed. Representative DeGraff.
Thank you, Madam Chair. It's kind of winding out of steam, but then now we have the gauntlet thrown of an hour, so I guess I've got to figure out how to fill an hour. So let's look at the bill, the unamended bill, because the amended bill would have included material to remove persuasive, emotive, or advocacy-oriented language. And now we've made that clear that so far And I'm going to give the sponsors another opportunity to rectify that and make it clear that that is not their intent, because so far it's the purpose. The purpose is deceptive language. So let's look at L007 if it's properly displayed, and it appears to be so. What I would like to do is I would like to amend the bill, page 3, line 5, and there's a word at the end of audience. Are written using accessible language. Great, we love that it's accessible language, which is plain language, which is kind of redundant and repetitious, but that's okay. That is understood. Now it's kind of repetitious, redundant, and duplicative. By the widest possible audience. By the widest possible audience. But that's all. What does that mean, understood? Is that comprehended? And to what level is that comprehended? Do they have a full grasp of what this bill, this title, this ballot title is about? Well, I would say no at this point, because the sponsors have made it their purpose to allow persuasive, emotive, and advocacy-oriented language.
Representative DeGraff, I just want to be clear on something. We have 54 minutes of debate. We have gone back and forth in regards to intent or purpose on deception. I will not allow that to be inferred or implied, whether or not you say the word purpose or motive. If you disagree, you have all of the right to debate, but the only people who can articulate what their purpose and their intentions are the sponsors. So please do not presume it unless it is expressly said. To the amendment.
It was expressly voted on. So let's look at page 3, line 5. And you're right, I should not have specified the sponsors alone when the body voted on it. This means in substitute audience, so we're going to have this language that's accessible, understood, and plain. And all we're going to do is add, without sacrificing neutrality or omitting material consequences of the measure. That's all. Without sacrificing neutrality or omitting material consequences of the measure. Now, the sponsors might say, well, that's implied in there. It's like, well, if it's implied, and it should be, it's not, but it should be. If it's not, then this amendment is easy. Why would you want to leave out something as simple as saying the audience, that it should be understood by the widest possible audience without sacrificing neutrality or omitting material consequences of the measure? And we can also go to page 6 because it shows up there again on page 6. And again, this is the language to add a neutrality guardrail. If we're going to allow persuasive, emotive, or advocacy-oriented language, we need a guardrail. And that is on page 6, line 3, strike audience. Are written using accessible language that is understood by the widest possible audience, and adding again, without sacrificing neutrality or omitting material consequences of the measure. Now, I would say here, when you say understood, that you're not merely speaking in terms of do you understand the language, but do you understand, do you comprehend the ramifications of that language? Do you understand, do you comprehend the outcome? Do you comprehend the consequences? And this is only written in terms of the language, but what I'm suggesting is we add without sacrificing neutrality or omitting material consequences of the measure. And the reason is we just want to clarify that word understood, because somebody let's say somebody down in the future that is inclined to include persuasive, emotive, or advocacy-oriented language that is not precluded by this bill, might also want to use that persuasive, emotive, or advocacy-oriented language to obscure the neutrality, to obscure the material consequences of the measure. So that's all we're doing, is we're trying to clarify not just the comprehending of the language, but we're comprehending what that language means, what that bill actually says, what that title actually says, what that description actually says. And you're not going to do that without the comprehension, and this bill only addresses the understanding of the language, not the comprehension of the consequences. And in fact, the bill goes out of its way to avoid the description and the understanding of the consequences. Now, the body goes out of its way to make sure that the consequences are not there. So this is just another opportunity to include that the audience will understand, the widest possible audience. We want the widest possible audience to understand the consequences of their decision. And so I would be at a loss to understand why the sponsors would not want the widest possible audience to understand the consequences of their actions, of their vote. So this is just an opportunity for the sponsors to clarify that they want the widest possible audience to understand not just the language, but the consequences. That's it. If they feel that this is already implied, fantastic, add the language. It's not implied. This bill is speaking about the language. And this bill already allows for persuasive, emotive, or advocacy-oriented language. So it is creating the environment whereby the widest possible audience will not know. I mean, that's already not neutrality. But they will not know the material consequences of this measure. So this bill currently is creating the environment, creating the opportunity whereby the citizens of Colorado will not know the material consequences of the measure. And so if somebody is aligned with securing those certain self-evident creator-endowed rights, I would find it really difficult to believe that they would not want the citizens to be fully aware of the material consequences of their vote. Because why else would we put it for a vote? Why would we put it for a vote? It's because there are material consequences. So I think the sponsor's going to actually accept this one, because I think the sponsors really do intend to make sure that the vote of the widest possible audience, without sacrificing neutrality, are aware of the material consequences of the measure. So I look forward to the sponsors accepting this amendment and ensuring that the citizens of Colorado understand the material consequences of their vote, despite the use of persuasive, emotive, or advocacy-oriented language that is permitted by this bill. So I appreciate in advance the sponsor's acceptance of this amendment, which will also be, not now, I'm not calling for it now, but will also be marked by division and account.
Okay. Representative One.
Thank you so much, Madam Chair. It is an honor to serve with you.
It's an honor to serve with you, sir.
We ask for a no vote. Thank you.
Would you like me to call for the division, or would you like to debate more? Okay, there's 45 minutes left. Representative DeGraff.
I mean, I would like the debate to be two-sided. I mean, that'd be awesome. Because what I would like to understand is why the sponsor is opposed to statutorily assuring that the citizens understand the material consequences of a measure. Why are the sponsors opposed to assuring that the material consequences of the measure are known? I was hoping that the sponsors would tell me that. Because it is my job here to secure these certain self-evident creator-endowed rights. And we do that through the process of self-governance, and we do that by putting these votes before the citizens. Now, I do realize that in this chamber, we're largely unaware or uncaring. That would be motive, but we're largely unaware of the material consequences of a measure. And that's our own doing. But if we are going to hide the material consequences of a measure behind persuasive, emotive, or advocacy-oriented language, as permitted by this bill, if we're going to allow activists to shape the title to hide the material consequences of a measure, I would just like to hear the sponsor articulate why it's important. I would just like to have the sponsors articulate why it is important that the material consequences of the measure are hidden from the citizens of Colorado behind persuasive, emotive, or advocacy-oriented language. That's all I want. I'm assuming that there's a good reason. I mean, besides extracting them farther without limit. But I would just like to have the sponsors explain why they want to conceal the material consequences of a measure behind persuasive, emotive, or advocacy-oriented language. That's all I'm asking. So if the sponsor, one or both, or you could even come up here with me. That's always tried and true thing that we haven't done for a while. I mean, those were the days. True. If you'd like to come up, I'd be happy to stand here and we could have this discussion, and you could explain why. You could explain to me why, one or both of you. I mean, I could stand off to the side, and you could both explain to me why it is important to be able for these bill titles to obscure the material consequences behind emotive or advocacy-oriented language. Why is this important? Why is this important to you to reject this amendment to make an environment where that can happen on the bill title? Why? Can you just explain to me why that is important to you? Why is the citizens understanding the material consequences?
Stay here.
All right.
Can you just lower it for me for a sec?
Okay.
Yeah, thanks.
I know, you just seem like you called who spoke, but Representative Garcia.
Thank you, Madam Chair. It is really awesome to serve with you.
It is dope to serve with you too, sister.
So I cannot answer the question that the representative from El Paso County is actually asking because it is not actually a fair question. What I think the discussion and the dialogue should lead us to is going back to the actual intent of the bill that we're bringing forward, which going back to this amendment, while sure, the amendment reads fine, the reality is that if we were to go through and look at the entirety of the regulations and the requirements and the expectations that a title board must adhere to when setting a title, it is already, especially with the addition of our bill, sans this amendment. Yeah, sans this amendment. We are already asking that the language be crafted in a way that is widely understood by the largest type of audience you can think of. We have outlined in the last committee report that we just debated for hours and hours and hours, the addition of the language that clarified what that should mean as guidance for the title board specifically. Saying no to this amendment does not mean that we are wanting to obscure anything. Saying no to this amendment is because how can we as a body agree to one part which says we want to clarify language for the citizens to understand while muddling our statutes with even more language to make it more confusing? I personally think that that would actually be counter to what our efforts are. That is why I'm asking for a no vote on this amendment. I want to clarify that if you vote yes on this amendment, you're voting yes for the reasons that you find important. If you vote no on this amendment, it's because you understand what currently lies in our statutes, what the current constitutional requirements are of the title board, and what our bill is attempting to do, and that this amendment is not necessary.
Representative DeGraff.
All right. I think it is a fair question. We are changing the language, and we have made this where we can take the implications here and said they can appear anywhere. And if you're talking about, so it is a fair question, and I suppose if we want to, we could more than read the bill, but we could read the entire statute, I suppose, that if that's what's being proposed, but that's on your time. More language to make it more confusing. And the language that I'm asking for is without sacrificing neutrality or omitting material consequences of the measure. So this is a check inside the language to make it more clear so that the citizens, that this is not just left out inadvertently. So when they go through this and they go, oh, we need to make sure that we have not sacrificed neutrality or omitted the material consequences of the measure. So that's all this is doing, is adding, this is not adding more language that makes this more confusing. This is adding language that just makes it more clear. It's not making it more confusing, it's making it more clear. So if it's already in the bill, let's assume that it is. Let's assume that it's in the statute someplace else, or it at least intimated that it is. Then this language, this clarifying language, just means in this new section that we're creating, that we make sure the comprehension is there and not just the understanding. So I still ask for an aye vote. I think the sponsor's intent is actually an aye vote, and so I ask for an aye vote, and again, for division when we get to that point.
Representative Garcia.
Thank you, Madam Chair. Members, I ask for a no vote.
Representative DeGraff.
And I ask for an aye vote.
Representative Garcia. No, I'm kidding. Representative Nguyen, let me guess.
I also ask for a no vote.
A division has been called. Okay, thank you. Okay, the question before us is the passage of Amendment L7. A division has been requested. All those in the chamber not entitled to vote, please sit and remain seated. All those in favor in amendment of L7, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. You may be seated. All those opposed, please stand and remain standing in one place, or raise your hand and keep it raised until the count is taken. You may be seated. Amendment L7 is lost. To the bill, Representative Garcia.
Thank you, Madam Chair. I truly appreciate the, please do. I truly appreciate the dialogue, the conversation that we're having around this bill. I want to just take the opportunity to actually talk about what this bill is supposed to be doing so that people understand the basis of this conversation. And I'm glad to have my colleagues standing with me because I do think that profoundly all of us standing here right now actually agree that we want easier to understand language in our ballots. We want to make sure that every single person that picks up their ballot can read the question and understand if they vote yes, what that means, if they vote no, what that means. Currently, because as I keep referencing, all of the countless regulations and expectations and all of the ways that we're directing Title Board to have to craft a single sentence question, which I'm sure all of us understand is a run-on sentence, makes it incredibly challenging at the end of the day, because it'll take an entire day to read a question, what that question actually means. Our bill is intending to make a small modification to allow flexibility amongst the Title Board to be able to craft the question so it can achieve the intended goals of clarity, of understandability, of knowing what your yes means and knowing what your no means. This bill is meant to make sure that people can understand the question. There is no hidden agenda here, and I'm stating that for the record, so please refrain from assuming there is any further. There is no hidden agenda. There is no intent of trying to hide the purpose of any question. The motivation behind 1320 is to make sure that the purpose of the question is fully, clearly understood. When any of us, if any of us are given the task with the many pages that exists in 140-106 of having to craft a single sentence question, I promise you, every single one of us would fail. That is why, constitutionally and statutorily, and with the approval and the continued directives of the Supreme Court, we are Our title board is directed to make sure that the questions that they put forward follow the law. Any of us would fail. There are 3 experts who are trained to do this with community input. The title board process is an open process. The title board process welcomes testimony, welcomes input, whether it's from question and review at the very beginning to understand the full intent of the question being brought forward, to the actual process of making sure the question matches the intent. Members, I also would love to see what we refer to the voters in plain, simple language as well. I would love for every single bill we write here to be in plain, simple language as well. I know, and we've seen in every single committee that we're in, every single time, almost every single bill, there is confusion on what certain things mean when it's written on these papers. That is because we do not write in plain language. I would love to get to this to address that. That cannot be done in this bill. But I am, on the record, committing to the representatives from Douglas County and the representative from El Paso, from where?
Otero.
From Fremont
Fremont.
County,
Fremont.
excuse me, and I guess El Paso. Sure. To work on this issue, because democracy at its core is understandability. It's knowing what the heck is happening in this building. It's so that any person can pick up any of these red books and understand what they say and what they mean, especially when they are the books that direct our every single day lives and every decision that we make in this state. This bill, this narrow bill, 1320, is meant to remove one of the many regulations, one of the many obstacles that exist, so that way we can have clear and understandable questions. That is what this is. This bill is about democracy. This bill is about community engagement. This bill is about making people feel like they are part of this process. This bill is about making sure that when people open their ballots and they take the time to sit down and analyze every question on the ballot, that they know what they're voting for. I believe it that every single person in this building gets the calls, gets the text messages, just like the representative from Douglas County said, saying, what does this mean? How do I vote? Just give me your voter guide. Tell me how to do this, it's too complicated. I believe that every single one of us has to deal with that every election, and that is not fair. That is not okay, and none of us should be okay with that, and I don't believe any of us are okay with that. That is why we are bringing this bill. There is no other purpose other than making sure that voters understand what they're voting for. That is the single and sole motivation and intention and purpose behind 1320. And I ask for an aye vote as soon as I am done talking. I'm just kidding.
My bad, was my mic on? Representative DeGraff.
Okay, so we're on board, on the same page here. The amendments were all good faith amendments to help in that regard. in clarifying that to make sure that not just the language is understood, but the ramifications are understood, so that we're not inadvertently creating an environment, because as the examples were given, there is a level of questioning about the non-biased nature when an organization of trained professionals can't apply simple definitions. So the environment for distrust was created. And what we're trying to do with the amendments is keep the bill, put guardrails around the bill for what we had assumed was the intent, and to say, we think that this is your intent, and we think that these amendments would clarify your intent, and we think that these amendments would prevent the bill from at some point going outside of your intent. So every single amendment that was brought was not brought for the sake of attacking. It was brought for the sake of clarifying what we had intended your position, what we had intended, what our understanding or our hoped understanding of the bill would be or was. And if those were the intents of the bill, then those amendments should have been easy to accept. It's the question arises when we bring good faith amendments forward that we think put guardrails around the nature of the bill, that we think that is going to keep it inside of your intent, and that makes those amendments make sure, and they say, we think we're just trying to clarify the intent to make sure that our understanding is the same as your understanding. If you want to build trust in this process, then you can look at those amendments and you can say, well, those are easy to accept. The distrust in this process comes when these amendments are just these simple amendments that just put guardrails around neutrality, put guardrails around ensuring that the citizens have not just an understanding of the language, but they have a comprehension of the consequences. So when you reject those type of amendments that are made, again, in good faith, and we just want to clarify that we're all talking about the same thing, when those simple things are rejected, it builds an environment of distrust.
Representative DeGraff, I can appreciate the explanation. We do not have an amendment before us. We have already voted on the amendments presented, and I would encourage you to now begin to debate the content of the bill. And so, again, I wanted to provide some latitude to be able to share that, but I'm unsure what we're debating now, if we are debating the content of the bill or whether or not amendments should have passed.
No, I was just explaining to the sponsor why we presented those amendments, and then I was about to step down. So
okay.
I'm going to be
Apologies.
done here. I think my colleague has an amendment.
Okay, Representative Wen.
Thank you, Madam Chair. I rise in support for HB 261320, accessible language statutory ballot title requirements. And this being one of my first bills here at the General Assembly for the 75th session, I just want to emphasize that we can all agree that ballot accessibility and ballot language is difficult. You need approximately a 22nd grade level to understand a Colorado ballot. And that is just unrealistic. Not everyone can have a PhD or a law degree to understand their ballots. And so the goal of this bill is to basically make for the common average voter to read their ballot. So I just want to emphasize that the language that this bill approves and supports is simple, concise, and accessible language. So we basically believe that this expands accessibility in ballot language, allowing voters to fully understand their ballot titles and to ensure that voters know the impacts of basically what they're voting on, yes or no. These ballots are already run-on sentences. They're extremely difficult to read, and this encourages transparency in how the state plans and uses ballot titles. So again, I stand in strong support of this bill, and I appreciate the time. And of course, I want to say thank you to the opposition, the other side, for coming up and introducing our amendments and having a verbose conversation and dialogue. So thank you so much again.
Thank you. Representative Luck.
Thank you, Madam Chair, and thank you to the bill sponsors. I do appreciate the conversation. I thought it was interesting to look back in time at some other ballot title language, just for the committee's understanding and information. So I'm just pulling some of these. You know, the first one, first Blue Book type thing I could find was from 1954. Actually, I didn't find it. One of our wonderful staff in Legislative Council found it for me. This is well before the Blue Book. It was just a analysis. In fact, it was titled Legislative Council of the Colorado General Assembly presents an analysis of 1954 ballot proposals. 1954, that's crazy. Long time ago. It's interesting because in that year, there were 8 questions posed to the people of Colorado, and all of the questions fit on a single 8.5 by 11 sheet of paper at regular, seemingly 12-point font. The first question was, actually the first 5 questions were under the heading Constitutional Amendments submitted by the General Assembly. And the first question was simply amendment to the Constitution of the State of Colorado, vesting in the State of Colorado the authority to regulate public utilities. Looks like conversations haven't changed much in this state. The second one was amendment to Article 12 of the Constitution of the State of Colorado relating to civil service. It's a whole question. We'll look at number 4. Well, no, let's just read them. The third, amendment to sections 1 and 19 and the repeal of section 21 of Article 4 of the Constitution of the State of Colorado relating to the executive department. Number 4, amendment of section 6 of Article 24 of the Constitution of the State of Colorado relating to old age pensions. Amendment to Article 5 of the Constitution of the State of Colorado relating to the General Assembly and the appointment of the members thereof. The next ballot initiative or ballot question was under the heading Proposed Law referred by the General Assembly. And it simply read, the construction, improvement, and reconstruction of public highways and bridges, and the issuance of state highway fund revenue anticipation warrants, the expenditure of such funds, and for the retirement of such warrants. The seventh question was under the title, or under the heading, Constitutional Amendment submitted by the General Assembly. It was amendment to Article 10 of the Constitution of the State of Colorado relating to taxation. And then the title heading for number 8 was Constitutional Amendment submitted by initiated petition. And its question was an act to amend Article 14, Section 8 of the state constitution to provide for a 4-year term of office, beginning in 1955 for the following county officials, to wit, clerk, sheriff, coroner, treasurer, superintendent of schools, surveyor, assessor, and county attorney who may be elected or appointed as shall be provided by law and providing for their salary or compensation. It's curious that even in 1945, the citizen-initiated petition ballot question was more convoluted and lengthy than the other ones submitted by the General Assembly, even back then. I just thought that was a bit of fun insight into the past. Definitely more plain language, less clarity. Now, the book that was published has analysis. It has the provisions that are being suggested and pro and con arguments listed out, but none of that is included in the actual ballot question. It's markedly different than some of these ones from 2012, 2013, 2014, which are basically as long on the page as half or more of the prior questions from 1945. Questions like, shall state taxes be increased by $70 million annually in the first full fiscal year and by such amounts as are raised annually thereafter by imposing an excise tax of 15% when unprocessed retail marijuana is first sold or transferred by a retail marijuana cultivation facility, with the first $40 million of tax revenues being used for public school capital construction as required by the state constitution, and by imposing an additional sales tax of 10% on the sale of retail marijuana and retail marijuana products, with the tax revenues being used to fund the enforcement of regulations on the retail marijuana industry and other costs related to the implementation of the use and regulation of retail marijuana as approved by the voters, with the rate of either or both taxes being allowed to be decreased or increased without further voter approval so long as the rate of either tax does not exceed 15%, and with the resulting tax revenue being allowed to be collected and spent, notwithstanding any limitations provided by law. We've come a long way from 1954. And so I do want to reiterate what I have sprinkled in throughout this debate, the statement that, as was mentioned by the bill sponsor, we are in agreement that clarity needs to occur. We do continue to have concerns about the fairness, as has been iterated at length this morning and afternoon. So I appreciate the work that has been done. I know that it is not just work that the two of you have taken on, but work from folks outside this building who are passionate about making sure that the citizenry knows what they're being asked to consider and that they are fully informed so that they can make the best decisions for themselves and their families. I think that is very important. I will also note that times they have changed, and there may be future conversations, just to put this idea out there, where perhaps in addition to the printing of the Blue Book, we move to video formats as well, as many folks struggle with reading more and more. And so if they can access that in a form that is more akin to TikTok, maybe perhaps there would be greater clarity. In any case, I appreciate the conversation.
Is there any further discussion? Representative Bradley.
How much more time do we have? Thank you, Assistant Majority Leader. I move Amendment L003 to House Bill 1320 and ask for it to be displayed.
Okay, L3 is displayed.
Thank you. And I appreciate the bill sponsors. There's not a lot of people that will dialogue and sit up here with us and listen to what we're saying. And I appreciate we're all going to be in the boat together and get this figured out. I'm going to hold you to it. You know, and this could be argued that this is already in the statute, but I sit on Health and Human Services, and a lot of times there's unclear wording like reasonable judgment, sound judgment, discretion, things like that. And we spend a lot of time on those committees and state affairs making sure that there's amendments to clarify or ensure that those words are clear. And so this is just an amendment to talk about it being fair and impartial. And I wanted to look up the definitions of what that means. So fair, treating all parties justly and equitably, free from favoritism, bias, or undue advantage. A fair process ensures that rules are applied consistently, that similarly situated people are treated the same, and that outcomes are not predetermined or influenced by outside pressure. And I can assure you, I've talked to a lot of you, there's a lot of outside pressure going on in this building. And I would say on ballot initiatives on both of our sides, there's a lot of million-dollar companies that come in to run these versus the citizen-led initiatives that don't have that money. It also means each party has a meaningful opportunity to present their case, respond to opposing arguments, and receive a decision based on objective criteria rather than subjective preference. That's why I think fair was a good term to use. Now, impartial, the second part of the amendment, acting without bias, prejudice, or conflict of interest. Boy, we need some lack of conflict of interest in here. An impartial decision maker approaches every case with neutrality, evaluates facts strictly on the evidence presented, and does not favor any individual group or political outcome. I would say we definitely need that when it comes to the title board and how they rule on different initiatives. Free from pressure by lobbyists, public opinion, or political leadership, a commitment to applying the law as written rather than as one might wish it to be. What it also does is these words carry legal, procedural, and political weight, and their inclusion can shape how the law is interpreted and enforced. One, it establishes a clear and enforceable legal standard. By explicitly requiring actions to be fair and impartial, the amendment creates a defined benchmark that agencies, boards, or officials must meet. Without this language, decision-making authority can become overly discretionary or vague. With it, there is a measurable standard that can be referenced in audits, oversight hearings, or title boards. It reinforces due process protections. Fairness is deeply connected to due process principles, something that I stand very strongly on, including it signals that any individual or entity affected by this bill must receive proper notice, an opportunity to be heard, and a consistent application of the rules. Like we're saying, is the difference between citizen-led initiatives and legislator-driven initiatives. It acts as a safeguard against political or ideological bias. And that, I believe the bill sponsors is truly their intent. In talking to them offline, is we don't want lobbyists and these big million-dollar companies to have this bias towards these citizen-driven initiatives. Limits unchecked discretion and overly broad authority. We have talked about that with the different definitions that I've come up here and talked about. Creates accountability and a basis for review or appeal. We believe in the fairness aspect of that, and that's why we've been fighting, because we believe in the citizen-led initiatives, and we believe that it should be the same standard for both. Promotes consistency across cases and situations. Again, why we're using the fairness term, it requires that similar cases be treated similarly. Builds and preserves public trust in government institutions. And I think that we have lost a lot of that as we legislate and create policies in this building. I think that public trust is being eroded, and it's a problem. Look at, I've got all kinds. Okay. Okay. Signals legislative intent for future interpretation, and that's why we use it in our statutory language regarding a lot of bills. And it counters influence from lobbyists or special interests, provides political clarity, and a principled stance. Fair and impartial is about requiring the system to operate on neutral, consistent, and transparent rules, not shifting standards depending on the individual, the issue, or the political climate. And again, I think that that's the fairness of this amendment. I do like the bill. I do think that all of our, I've told you, I'm getting the calls. I do believe that we all want the clear language. There's just a piece of this that we just can't cross the finish line on. So I would really love to have support of this amendment, and I urge, I'm gonna keep talking while she comes.
There's, hold on one second. There's 7 minutes remaining. Representative Garcia.
I just wanted to thank, again, the conversation. I also want to thank, I agree fully with the idea behind fair and impartial. I think it's also already covered. So please vote no.
Is there any further discussion? Seeing none, the question before us is the passage of Amendment L3. All those in favor, please say aye. All those in favor, please say aye. Aye. All those opposed, please say no. L3 is lost. To the bill. Representative Luck. George. You have 6 minutes and 15 seconds remaining.
6 minutes and 15 seconds. Thank you, Madam Chair. 6 minutes and 15 seconds remaining. So, I wanted to take a minute and thank, I suspect that some interested parties are listening in today to this debate. And I just wanted to thank them. I wanted to thank them for coming to committee on Monday. I also wanted to thank them for sticking around after the committee ended, well after normal business hours, to chat with me and to say, hey, Rep. Luck, we'd really like to get you to a yes on this bill. And the truth of the matter is I very much would like to get to a yes on this bill. I very much would. I believe that the title board should be able to set ballot titles that are brief, as was pointed out about the 1954 ballot titles, that are written using accessible language, defined further, as was pointed out in a prior. I appreciated the reading specialist and doctor of education who came in and provided us with examples and said, this is the same ballot title written as we write it now versus written how it could be if these standards were in place. And the one that was what it could be, definitely easier to understand. I appreciate that there is a desire not to allow for conflicting, which is already current law of the ballot titles, and that we are continuing to desire for the standard to be that a question is clearly a yes or no. Appreciate that that's not being touched. Why I will continue to be a no, though, is as relates to that financial language and the shifting of that information from the very beginning to the end, or the middle, or wherever it makes sense. I'm concerned about what that will mean for our taxpayer Bill of Rights and for the citizens' understanding that has been built over decades, that if there is a fiscal impact to a question, that fiscal impact comes from the beginning. It is noted at the top. I'm concerned that this will actually add greater confusion because people have come to expect that language to be stated first. I also believe the bill sponsor when she says there is nothing apart from seeking clear language at play here. And I believe that if this bill was introduced in my first year in office, there would have been a lot less hesitancy about some of these things. But we look at policies not in a vacuum. We look at them in light of a larger conversation and context. And the conversation that has been happening in Colorado, especially for the last couple of years, includes a desire to erode the taxpayer Bill of Rights. And so there are some that believe that even if this is not designed to be such, that in practice, using linguistic and grammatical approaches will erode that particular structure. Moreover, there has been a conversation about successful ballot titles that have impacted on the state's budget in a way contrary to what many on this floor of this building would otherwise desire or have chosen. And so it is just...
Members, I'm sorry. You don't have much time left. Please, Representative Luck. Please take your conversations to the side.
So it is part of the lens through which we now cannot unsee this bill. It is part of that larger conversation that makes us look at this policy and say, how is it going to impact on these other issues that are important to people in our district? And so, once again, I reiterate my gratitude to the bill sponsors for their engagement today, I am grateful for their desire to make sure that everyone in our state can participate in this important process of being able to self-govern. We are unique in our government structure, and I also want to do what can be done to preserve it. And so with that, I will be a respectful no, but thank you very, very much.
Is there any further discussion? Seeing none, the question before us is the passage of House Bill 1320. All those in favor, please say aye. Aye. All those opposed, please say no. No. House Bill 1320 is passed. Madam Majority Leader.
Thank you, Madam Chair. I move to lay over the balance of the special orders calendar till tomorrow.
The balance of the special order calendar will be laid over until tomorrow. Okay.
Thank you, Madam Chair. I move the committee rise and report.
Seeing no objection, the committee will rise and report.
The House will come back to order. Mr. Shebel, please read the report of the Committee of the Whole.
Madam Speaker, your Committee of the Whole begs leave for part under consideration the following attached bills, being the second reading thereof and making the following recommendations thereon. House Bill 1320 is amended, passed on second reading, ordered engrossed and placed on the calendar for third reading and final passage. House Bill 1195, 1304, and Senate Bills 88 and 118 laid over until March 26, 2026.
Thank you. Representative Zokai. Members, you have heard the motion. There are two amendments at the desk. Mr. Shebel, please read the first DeGraff amendment to the Committee of the Whole report, House Bill 1320.
Representative DeGraff moved to amend the part of the Committee of the Whole to reverse the action taken by the committee in not adopting the following DeGraff Amendment L6 to House Bill 1320 to show that said amendment passed, that House Bill 1320 is amended passed.
Representative DeGraff.
Just make sure I have the right one. I move to amend the report of the Committee of the Whole to reverse the action taken by the committee.
Representative DeGraff, I'll just have you move the first DeGraff amendment to the Committee of the Whole report.
All right, I move the first draft amendment to the Committee of the Whole report.
Thank you. One moment while we display. That is properly displayed. Please proceed.
Thank you, Madam Speaker. So this was just getting back to the purpose of bringing these was to address, just like my colleague ended with, that we're talking about being on the same page with this bill, and then just asking that there some guardrails be placed around this bill and the intent of this bill, so the bill does not go outside of those boundaries which are laid out. And then when those boundaries are rejected, then that creates the issue. So I wanted to bring the opportunity again to just put the boundaries on what the sponsor said the intent was in order to foster an improved environment of trust. And what we wanted was this, because not just understanding the language of the bill and not just creating a non-run-on sentence, but we do want to make sure that we do not omit fiscal material, regulatory or legal consequences of the proposed law or constitutional amendment, and then it does not use persuasive, emotion, or advocacy-oriented language. So again, from what the sponsors had said, this would be within the intent of the law. The reason for putting this language in, it does not complicate the law. It is a clarifying amendment, and it just keeps the bill from going outside of what the sponsor intended. And then the second amendment, or the second part of that, was just really to state that again in the second spot. And again, from what the sponsor said, this is the intent of the bill. We just want to make sure that the bill statutorily remains inside the intent of the bill.
Representative Garcia.
Thank you, Madam Speaker. Members, I urge a no vote. While we absolutely agree with what this says, there's already plenty of parameters within the Constitution and within statute that already are prohibitive of using advocacy-oriented language or persuasive language where the directive is to be fair and impartial, and so we ask for no vote.
Seeing no further discussion, the motion before us is the adoption of the first DeGraff amendment to the Committee of the Whole report. Mr. Shebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 19 aye, 42 no, and 4 excused, the amendment is lost. Mr. Shebel, please read the second DeGraff amendment to the Committee of the Whole report.
Representative DeGraff moved to amend the part of the Committee of the Whole to reverse the action taken by the committee in not adopting the following DeGraff Amendment L7 to House Bill 1320 to show that said amendment passed, that House Bill 1320 is amended passed.
Representative DeGraff.
Thank you, Madam Speaker. I move the second DeGraff amendment to the Committee of the Whole report.
It is properly displayed. Please proceed.
Thank you, Madam Speaker. And then this is just to kind of along that same line. Again, there's some areas because we're making these modifications. And I would, they just put boundaries on top of what the stated intent was. And that was when you're talking to the audience, audience without sacrificing neutrality or omitting material consequences of the measure. So that just creates, when you're going through this section, that it just creates basically a checkbox to make sure that while you're creating the neutral language, that you're creating the understandable language, that you're making sure that the language is comprehensive and comprehensible, and making sure that the individuals understand the consequences of their vote, not just the language of the ballot measure.
Representative Nguyen.
Thank you, Madam Chair. I rise in opposition to this amendment just because that the language and the audience itself is already being protected in our bill. We're already making sure that there's clear, concise guidelines, and this only just further, unfortunately, does not work with the bill itself. So I think overall, we want to make sure that the language is protected, and of course, the audience and the bill drafters are able to work without more further guardrails.
Seeing no further discussion, the motion before us is the adoption of the second DeGraff Amendment to the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
No.
Representative Morrow votes no. Please close the machine. With 20 aye, 41 no, and 4 excused, the amendment is lost. The motion before us is the adoption of the Committee of the Whole report. Mr. Schiebel, please open the machine and members proceed to vote. Representative Morrow, how do you vote?
Yes.
Representative Morrow votes yes. Flannel and Richardson. Please close the machine. With 41 aye, 20 no, and 4 excused, the report of the Committee of the Whole is adopted. Members, any additional announcements? Representative Froelich.
Thank you very much, Madam Speaker. We know that the Transportation, Housing, and Local Government Committee is meeting upon adjournment of the upon adjournment committees in LSBA. I just want to make sure folks know we moved 1061 for action only up to the first slot, and then we'll do 26, 1300, 1330, 1313. Thank you.
Thank you. Madam Majority Leader.
Thank you, Madam Speaker. I move to lay over the balance of the calendar till Thursday, March 26, 2026.
The balance of the calendar will be laid over until tomorrow. Madam Majority Leader.
Madam Speaker, I move that the House stand in recess until later today.
Seeing no objection, the House will stand in recess until later today.